may I get leave to file one mandamus appeal without certified copy of the order, Lordship?
When was the order passed?
Order was passed on 19/3/2025.
Have you applied for certified?
Lordship.
When?
Okay.
Have you annexed the certified copy application?
Certified copy application. Yes. Certified copy applied, Lordship.
When did you apply?
Lordship, agency is that one pipeline is going over the master land of my land.
So when did you apply for the 19th was the order?
Oh, apply copy. Yesterday applied.
And today we are on 26. Why didn't you apply for certified copy immediately?
There is the urgency, Lordship.
For urgency, you ought to have applied for certified copy.
Yesterday I applied. Kindly grant me.
Leave granted, yes.
Well, may I be permitted to mention extremely urgent matter, my lord, the fixation.
Tomorrow with notice.
My lord?
Tomorrow mention with notice to your other side.
My lord, I have served upon the, this is, my lord, I have this stay application. Urgency, my lord, the pay has been refixed of the appellant, my lord. After the...
so it is a new application?
This is a new application, my lord. It needs to be, my lord, heard. Stay.
When did you file it?
My lord, I have filed the stay application yesterday, my lord. And my lord, the mandamus appeal has been filed a little bit earlier, my lord. And the...
there was no urgency.
There is.
With an application immediately after filing the appeal.
Yes, immediately I have, after filing the appeal.
Did you file it, sir?
My lord, I have filed the appeal on 24th, my lord. And I have filed the this stay application. It was ready and made yesterday I filed it, my lord. My lord, it will
give a notice to your other.
I have given a notice by email. I have given a notice, my lord. My lord, may it come tomorrow, my lord.
You cannot ascertain that it will be requisitioned. If the file comes, it will be included. Yes, call the.
My lord, may I
my lord,
I'll be mentioning, my lord. One matter, my lord, I'll be seeking for.
Please mention tomorrow, sir. Tomorrow is the mention.
Lordship, it is only with respect to the matter which was heard yesterday. Lordship, I checked up the records. Lordship, they were present in court before the trial court. Mr. Kundu was there. I had also spoken to him. It was accepted without prejudice, Lordship. This, Lordship, it is my duty to inform my lord. I'm
all right. We shall give us that. We shall include that.
Lordship, I have indicated because the matter was taken up for hearing on several occasions. And in one occasion, Lordship, it also records that I have accepted.
Our main question to you was, is this quantification featured your main writ petition or not? You have argued.
Quantification has not been featured.
So we have considered that and we have passed an order. So you want to include that without prejudice?
Yes, ma'am.
We will include that.
And Lordship, I'll just take half a second more. Lordship, yesterday they had given a slip in which they had stated that all the calculations have been given. Lordship, on a bare perusal, because it is part of the record, on a bare perusal, it is a statement of 2011. Lordship, which and they handed over the check, Lordship, whatever it is according to their in 2024 and not prior to that, Lordship. Lordship may kindly consider those. If Lordship requires any clarification, I'm there, my lord. I shall serve a notice upon my other side if they need to be, my lord. I'm grateful.
Sorry, Mr.
I'm grateful, man. Item number 9 chilo gotokal. Ami slipটা দিবি. Item number 9.
করেছে সিভিল আরটি। হ্যাঁ, যেহেতু সিভিল ডিভিশন ছিল। আরো সাইড সব হয়নি না, ক্যাবিনেট নেই আর এক্সপিডিশন ডিসমিস এক্সপিডিশন করতে চাইছি, আর কিছু চাইছি। এলসিআর আসছে না, এলসিআরটার জন্য একটা যদি স্পেসিফিক ডিরেকশন করে নেওয়া যায়। 10 বছর হয়ে গেছে এখন, এলসিআর কিছু আসছে।
You bring Mr. Kundu at 12:45. If I take those yes.
Well, this is essentially for expeditious disposal of a statutory appeal which has been pending for the last 10 years.
before my lord the jurisdictional additional district judge in charge, who is the EA tribunal according to the statute. My lord, the lower court records are not being sent down, my lord, to the learned appellate court by the government, despite several intimations having been served. This was initially originally by mistake filed before the honorable single judge and then converted into a COLRT because, my lord, this is a specified act under the Land Reforms and Tenancy Tribunal Act. Humbly beseeching for your lordship, my lord, directs the learned court of appeal below to hear out and
Who is your
dispose.
service? Who is your other side?
My lord, I am told that there is no caveat. This is a CO. Therefore,
Serve upon the response.
fair enough. We'll do that, my lord.
Serve upon the response next Thursday.
Obligation.
Lord, I appear for the petitioner.
Yeah,
Appellate.
from the union.
Hey, Kartik, shun.
For absence without leave is the charge, my lord. According to them, 199 days. And in our calculation, it is 136 days, my lord. My lord, on the last occasion, your lordship desire was to see as to whether he is 37 years old or not. My lord, I have brought birth certificate from the Department of Planning and Development, Government of Bihar. And the appellant is also here, my lord, present. And this is from a certificate from board. It is in Hindi.
Yes.
My lord, in this
Now,
matter,
challenging that you have filed this present appeal.
yes, my lord.
This order of 20th September 23.
My lord, yes.
Now, there is a delay of how many days?
199 days according to them, and according to us, 36 days. In view of the fact that when he went there to join, he was the authorities refused to induct him.
When did he go to join?
He went there 16 February 2012. 16 February 2012.
We are not on that. We are on the ground of delay in filing the appeal.
My lord, yes. That is, my lord, in view of the fact that first he went to a particular learned advocate who filed a case in Central Administrative Tribunal. Central Administrative Tribunal rejected on the ground of jurisdiction, my lord. Thereafter, the learned
You
advocate.
know that. You
Well-
explain the delay from the date of passing the order. What you have written in your say section 5?
Section 5 has not been.
There is no section 5 application.
Huh? Where is the section 5?
There is no section 5, my lord. There is no need to file the section 5 in view of the fact that it was pleaded before the learned single bench that I was held up due to the fact that the learned advocate.
For that you are not required to say anything why the delay appeared after dismissal.
Yes,
of
I have explained in writ petition. In the writ petition.
আবার বলে writ petition. We are in appeal.
My lord,
You are challenging an order passed by a single judge.
my lord, there is no delay.
You filed it within time.
Yes, my
Appeal.
lord, within time.
You filed the appeal in 2023
Yes, my lord.
December.
Yes, my lord.
আচ্ছা আচ্ছা।
It is within
Oh,
time.
there is it is within. Yes. Yes, tell us why should we interfere with the order?
My lord, in view of the fact that the learned judge refused to believe that it was due to the mistake of learned advocate at Bihar who did not inform the petitioner that he has lost his case.
For 5 years.
Yes, my lord, that for that
Did not meet with
for
your
that the petitioner has initiated proceeding before the State Bar Council of Bihar, and the Bihar State Bar Council has in a general body meeting, my lord, kindly have a look, page 63, last annexure, page 63. May I read it out? Page 63.
You made the application to the Bar Association
Bar Council of West Bihar, that
on 29 July 2023.
my lord, yes,
When your writ petition was dismissed
yes, my lord,
in the year 2018. So from 18 to 23,
yes.
you slept over there.
No, my lord, that is why I have
You
initiated.
made the application on after 5 years, sir.
Yes, my lord.
So these 5 years, you cannot see condonation because you have made an application that the lawyer did not intimate me after 5 years.
Yes, my lord. That is why he told me that it is pending.
Where
He
is
was-
that statement that immediately after November 2018,
Yes,
you
ma'am.
went and met with the lawyer?
I did not meet. I just telephonic conversation was there that he told me that he is it is pending. It is pending. That is why State Bar Council has taken cognizance.
5 years, sir.
Yes, my lord.
You are not understanding what we are saying.
My lord. Yes, my lord.
Show us that where telephone call you have mentioned.
My lord, may I show the writ petition?
You check it up yourself and tell us.
Yes, my lord. Just a second, my lord. My lord, I have annexed the writ petition, my lord. It is running page 28. May I read it out?
You please show us that portion.
Yes, my lord. My lord, kindly have a look. It is,
You read out.
my lord, that the petitioner was in dark about the developments of the aforesaid last two proceedings in the tribunal and the High Court of Judicature at Patna. The learned advocate, Mr. Jitendra Kumar, who was dealing with the case of the petitioner, had neither informed nor provided with any documents with regard to the aforesaid two fruitless proceedings. with all the time, the said advocate informed the petitioner that the case is pending. But when there was no development for years together, the petitioner approached the said advocate and requested him to return the papers. Then ultimately on 6 July 2023, the case
Then
filed.
what happened? Papers were returned in 23.
Yes, my lord.
Your application was dismissed in 2018.
18, yes.
Sir,
Yes.
we are asking a question. If you purposely do not listen to our question,
My lord, yes.
we are asking, show us that portion of the writ petition where you have explained the delay from 2018 till 2023.
That is what I'm describing here. It has been described here, my lord. That all the time he was giving assurance that yes, it is pending. It is pending. That is why Bihar State Bar Council has taken the cognizance. It's a very serious issue, my lord.
And when were you engaged as the lawyer?
Me, myself, 23.
Oh. And you filed the appeal
Writ
in
petition.
20,
Writ petition. I filed the writ petition.
in 23.
Yes, my lord. Before that, my lord, I have, my lord, the petitioner has written a letter to the State Bar Council. It is also annexed, my lord. Kindly have a look. It is before filing the writ petition. It is at page 54, dated 29th July 23.
You show us the amendment in the writ petition explaining the delay from 18 to 20.
I have
Paragraph.
paragraph 14 of the writ petition, page 28, running page 28.
28. Yes. Read.
Lord, that the petitioner was in dark about the development of the aforesaid last two proceeding in the tribunal. He did not know about any of the proceeding. And the High Court of before the two proceeding in the tribunal and the High Court of Judicature at Patna. The learned advocate, Mr. Jitendra Kumar, who was dealing with the case of the petitioner, had neither informed nor provided with any documents with regard to the aforesaid two fruitless proceedings. I was not even informed that these were.
Is it not your duty to contact the advocate?
Lord, it was all the time.
5 years. Who will believe this?
All the time I was contacting him, but he did not. Lord,
Where is that pleading?
that is what I'm reading.
In the 5 years you contacted, show us that pleading.
Lord, that is what I'm reading. Let me.
That is not sufficient, sir. You
Well,
explain which line you are saying.
My lord, yes. Two fruitless proceedings. All the time, the said advocate informed the petitioner that the case is pending, but there was no development for years together. The petitioner approached the said advocate and requested him to return the papers. When the return in
When
July,
did you approach and return?
even he was not returning. Then ultimately on 6 July 2023, he returned the paper. 6 July 2023. Thereafter, he has written this this paper to the this letter to the State Bar Council, that is annexed, my lord, before filing the writ petition. It is 29th July 2023. My lord, thereafter, upon study of the said file, the petitioner came to know that there were two futile attempts by the said advocate, knowing fully well that the case was not going to be entertained for want of jurisdiction. Even after the passing of the last order by the Patna High Court on 2011-2018, the said advocate should have handed over the documents of the
Where
case.
you are reading?
Lord, it is page 28. Even after passing of the last order by the Patna High Court on 2011-2018, the said advocate should have handed over the documents of the case to the petitioner, but he kept the same in his custody for reasons best known to him. By keeping the said file in his custody on the false pretext that the case was pending in Patna High Court, the said advocate has done enormous damage and irreparable loss as far as chances of my reinstatement in service is concerned. Against the said misconduct by the said learned advocate, the petitioner by a letter dated 29 July requested the President Bihar State Bar Council to inquire and take stern action against the said advocate by cancelling his license to practice. Lord, that letter has been entertained by the State Bar Council, and cognizance has been taken by the State Bar Council against the said learned advocate. That is page 63.
Where is your charge sheet?
There is no charge sheet, my lord, only show cause. It is appearing at page number 25,
Page number 37 of the stay.
37 of my Can 1.
So you did not reply to this page 37?
No, my lord, since I have replied. I have replied. My lord, it is page.
It was not replied.
Just a second. My lord, he went there on 16 February 2012. 16 February 2012. Just 1 month after. Just 1 month after this show cause. And he was denied by 2 officers. And that was seen by the clerk of the BSF camp. And that clerk has on oath submitted that, yes, he came there with representation.
What is that?
Yes, my lord. It is at page 20.
Page 40 of the stay application. It's the English version, my lord, and page number 39 is of vernacular language.
Page 40, my lord.
Yes, you are not allowed to join.
Yes, I was not allowed to.
Is that you were not, you went to deposit the show cause, they did not get it.
Yes, that
Where is that version?
that averment is there, my lord.
Page 40. Come to page 40.
Page 40, yes. That my lord, the relevant portion I am reading out. That I was doing the duty of diary clerk in 119 Battalion on 16 February 2012. That on 16 February 2012, number such and such, Constable Pramod came to 119 Battalion, BSF, Simanagar Nadia to get his name's arrival entry in the daily register from 11 a.m. to 1 p.m. Went to the deputy commandant with the request letter for arrival in battalion book. There, the company commander, Mr. Ranveer Singh, the assistant commander, was also
So
sitting.
your request was to get your name entered in the arrival entry.
Yes, ma'am, with letter.
By that time, you were dismissed from service. So how they can allow you
Not,
to serve?
I was not dismissed. Later on, I was dismissed.
Show cause was issued. Sorry,
Show
show
cause.
cause was issued.
Yes, yes.
Yes.
Against that, I went there.
You are
with-
submitting something, your record is something else. You are submitting, I went with the show cause.
Yes,
I went with the show cause to submit. They did not receive it.
I went with a letter to submit after getting the show cause.
Where do we find?
Yes,
any
my lord.
evidence?
Kindly have a look. Paragraph number 4, as page 40. That on 16 February 2012, number such and such, Constable Pramod came to 119 Battalion Border Security Force, Simanagar, Nadia, to get his name's arrival entry in the daily register from 11 a.m. to 1 p.m. went to the deputy commandant with the request letter, I'm emphasizing on that, with the request letter for arrival in battalion book. There, the company commander, Mr. Ranbir Singh, the assistant commandant was also sitting there. The arrival application was not accepted. My lord, which, of which I am an eyewitness. My lord, a clerk on a risk, he has taken this oath.
Hmm.
I affirm this affidavit.
Yes. Anything else, sir?
Yes, my lord. Thereafter, your lordship has seen this resolution by the board, general body meeting of the bar
Yes,
council.
that you have shown us.
Yes, my lord. My lord, that's all, my lord. My humble submission.
May I, my lord?
Just a second, my lord. There, as far as age proof is concerned, my lord, there is another document by it is Government of India new pension system. That is 37 years, 38 years old.
Huh? Yes.
My lord, the show cause notice was issued, my lord, on, my lord, 21st February 2000 and my lord, 12, page number 37, my lord will get. Page number 38, my lord, kindly see. Prior to issuance of the notice, my lord, that show cause notice, several opportunities were, my lord, supplied to him, the appellant, to get back in the service. Letters were issued, my lord, kindly see. 14th October, 24th of October 2011, 2nd November, 12th November, asking him to join, asking him to come back. So he cannot say that all of a sudden that show cause notice was issued.
No, those letters were of 14th October 2011,
my lord.
24th October, 2nd November.
And my lord, 12th November, my lord.
Yes.
Now, my lord, at page number, it is very illegible, page number 41, the order of dismissal, my lord. It is of, my lord, 16th of March 2012. The show cause notice was issued.
এই একটু বিএসএফ একটা দাও তো।
Inquiry was held by the court.
Where is this is the final order?
This is the
16th March.
16th March.
Uh.
Dismissing him from service.
Where is the inquiry held?
My lord, I didn't.
Inquiry?
Inquiry, my lord, inquiry by the held. It is mentioned in the, my lord, show cause notice. At page number, my lord, 37. My lord, may I read out? Based on the reports available, it is noted that you have illegally absented without leave with effect from 2nd October 2011. The proceedings of the court of inquiry held in accordance with section 62 of the BSF Act to investigate into the said illegal absence has also found and declared that you have been absented without leave with effect from 2nd October without sufficient cause. That my lord, in accordance with section 62 of the my lord BSF Act, the inquiry was held, and my lord, thereafter the show cause notice was issued. Thereafter, my lord, the affidavit that my learned senior was indicating at page number 40, that the constable on bona fide has affirmed that affidavit to help his friend or the or my colleague. Not, my lord, it was affirmed. Kindly see the my lord date of
22nd
affirmation
March 2008.
after the passing of the dismissal order. So if my lord, had it been a case that he was so keen to help him, so it could have affirmed, my lord, prior to issuance of that order of, my lord, dismissal. My lord, that apart, the appellant has been habitual in doing misconduct, my lord. My lord, there are, I am submitting on instruction, my lord. My officer is also here in the court, my lord. My lord, he overstayed on many a times, my lord. During his service,
Cannot take into consideration his
My lord,
previous
my
conduct.
and my lord, may I then, my lord, place only one judgment, my lord?
What is this page 43?
Page 4.
That is his representation was concerned.
My lord, forcible dismissal from service. It has been recorded in the impugned order also that he approached after, my lord, order of dismissal, my lord, that too even after 2 years, he filed that appeal, my lord, statutory appeal.
Where is that?
My lord, in the impugned order, it's mentioned, my lord. Kindly come to, my lord, page number 58. My lord, internal page 2, my lord. Against such order of dismissal on June 18, 2014, more than 2 years after the date of order of dismissal, that statutory appeal was, my lord, filed. Then, my lord, I'm just reading, such prayer was rejected by an order dated July 7, 2014 by the appropriate authority. Again, an application was made by the petitioner after July 2014. Such application was rejected by the appropriate authority on November 24, 2014. A further application was made by the petitioner, which was for reinstatement, and the same was again rejected on June 15, 2015. It was also recorded in the said order that the petitioner's prayer was already rejected on November 24, 2014. The allegations against the other members of the force regarding misguiding the petitioner were examined and found to be baseless by the appropriate authority. Then, my lord, he went up in the Central Administrative Tribunal, my lord, at my lord Patna in 2015. My lord, if I may be allowed to submit one thing, my lord, my learned senior as well as put the allegation on the or my lord, the burden on the erstwhile advocate, my lord. The order of dismissal by the CAT was passed in the, my lord, 2015. Then, my lord, writ petition was filed in the year 2016 by the same advocate.
Writ petitioner application was filed before the tribunal, which was dismissed on 27 November 2015.
15, my lord.
Yes.
The petitioner filed the writ petition being numbers
Then he filed the writ petition.
16. So the information whether that application made before the CAT was dismissed or what is the fate of the application.
No, that does not arise because he filed the writ petition thereafter.
And my lord, may I, my lord, place?
Where from you know that he had been the same advocate all through?
It is his case, my lord. He has averred that, my lord, at page number 28, my lord, of the stay application.
Yes.
My lord, one judgment, my lord, may I cite, my lord, on the point of, my lord, abandonment of service, my lord. My lord knows it very well
that is not the ground on which the writ petition was dismissed. Anyway,
My lord, may I hand it over to my lord, Mr. Mitro? My lord, it is highlighted, my lord. My lord, page number 18, my lord, I was citing the second last paragraph, second last line of that page, my lord.
paragraph.
18, my lord, 1-8.
Hmm.
The second last line of that page.
Hmm.
My lord, proceeding on leave. My lord,
Yes.
proceeding on leave without the same being sanctioned or overstaying after the period of sanctioned leave is over would undisputedly come within the purview of the term misconduct. It is, however, true that only because the action on the part of the employee to avail leave without any prior sanction thereof or overstay despite expiry of the period of leave would amount to misconduct. The statutory authorities would not be denuded of power to make an appropriate statute, then in certain situations the employee would be deemed to have abandoned his service.
How this is relevant?
My lord, with my lord,
That is, the authorities would be a,
authority has the power to
they
my
will
lord
they will frame appropriate statute
statute to my
putting
lord,
in the provision of abandonment of service.
my lord,
How does that
so that
appear?
so that the employee who is absent without leave or overstaying on leave and the establishment of misconduct can be against him, any my lord action can be taken. So in the instant case also, my lord, in terms of section 62 and also my lord rule 22 sub rule 2 of the BSF rules, the action was my lord taken.
Yes. Anything else?
Another judgment that I on the ground of my lord delay, my lord. My lord, it is reported in 2014, volume 4, Supreme Court cases, page number 108. My lord, paragraph 16, my lord. 2014, volume 4, Supreme Court cases, 108. Thus, the doctrine of delay and laches should not be lightly brushed aside. A writ court is required to weigh the explanation offered and acceptability of the same. The court should bear in mind that it is exercising an extraordinary and equitable jurisdiction. As a constitutional court, it has a duty to protect the rights of citizens, but simultaneously, it is to keep itself alive to the primary principle that when an aggrieved person without adequate reason approaches the court at his own leisure or pleasure, the court would be under legal obligation to scrutinize whether the lease at the later stage should be entertained or not. Be it noted, delay comes in the way of equity. In certain circumstances, delay and laches may not be fatal, but in most circumstances, inordinate delay would only invite disaster for the litigant who knocks the doors of the court. Delay reflects inactivity and inaction on the part of litigant who has forgotten the basic norms, namely, procrastination is the greatest thief of time, and second, law does not permit one to sleep and rise like a phoenix. Delay does bring hazard and cause injury to the lease.
Yes.
My lord, these are my summary.
Yes, you want to say anything in reply?
Lord, it's not that I have not written representation. I have written representations in the meantime as well. My Lord, it is, but that was not kept with the petitioner. He just posted and just forgotten. But that they have reckoned, they have acknowledged that they have received.
Where?
Yes, my lord. My lord, in their letter dated 7th July 2014, my lord, it is appearing at page number
7th July 2014.
yes, my lord. Their letter,
Yes. Page 44.
page 42. Yes, my lord. Kindly have a look. It is not legible, my lord.
Next page is the type page.
Next page, yes, my lord. My lord, regarding forcible dismissal from service, I have written that it was forcible dismissal. Kindly refer to SDGE.
It was written by you?
No, it was not written by me. It was written by the BSF authority.
Yes.
They have replied to me, to my letter, which was not kept with me.
That has been denied. Paragraph 4.
No, my lord, it is, my lord, that allegation has been denied. Allegation, I have.
Where is that they received your?
My lord, that's paragraph number 2. With reference to your petition on the subject stated above.
Sir, read. We are reading.
Yes, my lord. With reference to your petition on the subject stated above, on 2nd October 2011, you were absent from battalion headquarters of this unit without leave on FIR to this effect was lodged with police station Chhapra, district Nadia, West Bengal. Proposed, but there was not legible. That's why it was not stated. Proposed, but you did not reply it, and accordingly, as per rule, you were dismissed on 16th March 2012. BSF is a very disciplined force, and hence the decision of this.
So where is that line?
Yes, my lord. So far as your allegation, from where I have they have got the allegation, I have written that. That's why they have got.
What did you submit before us? That I went and deposited the reply to the show cause that has been recorded in this order.
My lord, that
was submission.
No, not at all. Not at all. I was submitting that in the meantime, I have written letters, but copy was not kept. My lord, it is.
Where is your letter copy? Is not.
Copy is not.
Fantastic.
But they have reckoned.
Lost your service and you will not give a protest letter, you will not get a copy.
My lord,
and you are in a disciplined force.
My lord, that is fault of mine.
There must be a limit to exaggeration of facts.
My lord, but they have reckoned. They have acknowledged that I have written.
Where is that
My lord,
line?
it is kind of have a look. So far as
you have just now said that they have reckoned, they have admitted that show cause reply was given. You have just now said?
No, not show cause reply. For reinstatement. For reinstatement. My lord,
sir, we are on the issue whether you replied to the show cause.
My lord,
statement comes later, that is after you are dismissed.
Yes, my lord. After I was dismissed.
So prior to dismissal, you had an opportunity to reply to the show cause.
Yes, my lord.
That you have not done.
I went there with the letter, but they have not entertained me.
Tomorrow you will say, I went there not only with the letter, but with the advocate.
But my lord, the affidavit by the head constable come clerk by the same institution is.
That is not your reply to show cause. That was you are not being allowed to join. That is why that registered incorporation was not.
My lord, with letter.
You have tried your best, Mr.
He said that with letter I have he has arrived.
Come with a better case.
My lord,
the present appeal has been preferred.
अच्छा बोला
Lordship, the service is already completed. On the last occasion, I have served the exception to the report. The private respondent is absent, Your Lordship.
Reply.
Ah.
Bring for the state.
Yes, sir. What is the matter?
The case of the appellant petitioner was that she was an aspirant for the post of an ASHA worker.
Yeah, just give us one moment. Let us go through here. Now, state has given the opposition and reply,
Lordship.
but that person is not appearing.
No. She has been made a party in the writ application. She
Huh.
never appeared. Here she appeared once through her advocate, and now
Appeared.
once she has appeared, but thereafter she has not surfaced. We have
Dipayon Da. Dipayon Da. কি বলবো বলো তো? ওর চাকরিটা যাও। ও যদি যেত, ওর চাকরিটা যাও। হ্যাঁ, একদিন অ্যাপিয়ার করেছিল। What do we do, Mr. Ghosh? Do we hear it in his absence?
Lordship, I don't think she is interested in this.
Now, suppose we hold in your favor, his service will go. কি করবে বলো? সার্ভিস করেছে, একটা অ্যাডভোকেট এঙ্গেজ হয়েছে। এই যে
No, can notice be given as the last opportunity, kindly keeps it next week, Malad. Otherwise, it is ready for to be taken up, Malad.
you have filed a report as well as an affidavit.
Malad, I have filed a report. I have filed an opposition as well as a opposition to the supplementary affidavit. To that, they have used the reply.
Hmm.
There is the original opposition and reply, then opposition to supplementary and reply.
The we have been informed. We have been informed that the
Yes, may I be allowed to file my opposition, my lord?
The reply is also.
Opposition,
The lordship had passed my lord's orders on earlier occasions.
ওইখানে
So, Mr. Bhattacharya, there is no scope for any interim order. He has been dismissed from service.
My lord, I tell you, lordships, my lord, so far as the matter is concerned, 2 points I will be only indicating.
No, we will, you come with a paper book, come with a paper book and we will fix the date of here. There is no scope for it. And in the writ petition, whether affidavits were exchanged.
no, there is no. If it was
Writ
exchanged.
petition, no affidavit.
No, no. No, no.
No.
But only one thing I would like to point it out, the person concerned is a contractual employee. Is the terms and condition is giving, if the satisfaction upon the renewal is depend upon
You are
the
not
satisfaction.
hearing the appeal, Mr.
Yes,
Sir.
naturally, my lord, I do
So
appreciate
the
that.
present appeal has been preferred.
Very good.
Lordship, I'm for the respondent bank. I am led by Mr. Victor Chatterjee. He is on his legs in court number 26. Kindly praying for a pass, Lordship.
This way, if you fail the schedule, it becomes difficult for the court. We had concluded hearing. We only wanted to hear him. And now you are saying he is before another court.
It's a 12 p.m. fixed matter.
12 p.m. He ought to have made necessary arrangements before that court.
Lordship, he is on his legs actually. He's
What else put you on?
So, madam, you are also on your legs. It is not a great thing to be on legs. The thing is that the advocate should be cautious. Before the division bench, at your instance, we fixed 12 o'clock. You are saying he is engaged in another matter. Who
Lordship,
is the writ petitioner? Writ petitioner এখানে?
Malad, I'm
kindly short pass over, Lordship.
Wait, pass over, let him if he comes. Let us. This is not done.
Sorry, Lordship.
Call him that you immediately come after your matter. He's arguing. Do you know that?
Lordship,
His clerk has intimated you, tell the court he's arguing.
Lordship, he is on his legs. That is what my information is, that
That is
he's in
your
court. Item
information,
number.
madam. You may have been misled also. Your junior counsels do not always take your clerk's advice as the solemn advice. Please check up that whether you will be embarrassed or not. Your clerk is not the picture. You are being embarrassed. We are telling so many things to you.
In item number 1,
Yes, call the next matter. তাহলে আর কি করবো? তাহলে we-
I also want to finish it up.
we'll want to do it.
I beg to oppose this application.
Why you are begging for opposing this?
Section
You have
5,
a right to oppose.
Section 5 is the because
Section 5 application, there is no
কতদিনের delay?
Section 5 application, because the delay is
425 days.
পড়েছো?
reason there is
Number is not factor. Factor is my sufficient cause whether demonstrate or not.
It's against a dismissal of review petition.
Review petition
along
thereafter
with the main petition.
writ petition allowed thereafter.
It is allowed. I paper reviewed and
Thereafter,
dismissed, and we file paper appeal against both the review
The
and
orders,
matter.
both the orders you preferred.
So because at that material point of time, when the order was passed by the trial court, that Allahabad Bank
I shall take
and
my lord's attention in paragraph 28 and 29.
Let him finish.
the Allahabad Bank and Allahabad Bank was merged with the Indian Bank, and that there is a time at the point there is situation is not clear, and that's why they could not take steps for the purpose of this, and thereafter
Proceeded in contempt.
Yes.
and
They
thereafter
took time for the landed court.
and thereafter I prefer the review application. And review application, after dismissal review, I file this appeal before this court. The fact matter is that in this case, my lord,
What was the wrong with the order?
wrong is my lord.
Where was the writ petition order?
Yes, my lord.
11
If there is my lord consecutive suppression of fact.
That is why you came after 400.
My lord. No, my lord. Fact, my lord.
Allahabad Bank. হ্যাঁ বলছি 68 days delay.
They have stated 425.
That is, they are taking the writ petition in
Petition.
My lord.
But my lord, if your lordship turn to the paragraph 28 and 29 of application for condonation of delay.
What was the matter about? Tell us.
Yes, ma'am. Allahabad Bank, at the metropolitan Allahabad Bank was there. Allahabad Bank published a notification in the paper. And there is in that notification, they asked peon for the post of peon, and his educational qualification was asked that it should be class in first, their first notification that it should that they said it is not is more than class 10.
Hmm.
And immediately thereafter, next day, they issued correspondence.
Where is the order passed in the writ petition?
Order,
5th
this one
August
page 60,
2004.
page 66, my lord.
Page number ও করোনি।
No page
File without giving the page number also.
Page 68, my lord.
My copy of
What is the date of the order?
11th August.
That was 11th August 2023. And immediately thereafter, published,
yeah.
we published that correspondence. Even thereafter, he applied before
Okay, give us 2 minutes.
my lord. This factor is not relevant.
You are a sweeper.
Well, kindly come to annex
Yeah,
14.
just.
Madam. Yeah. अरे बुझते हैं, नहीं बुझते।
Yes.
Kindly come to page 14, first advertisement. And where it is next page, my lord, is English
14.
translation.
Page 14.
Page 14, 1-4. And
Yes.
and thereafter English translation,
Page,
page
page.
15, 16. Kindly count to page 16. This is the English translation of the page 14.
Page 16.
16, madam.
Yes.
First criteria, eligibility. The candidate should have passed 10 class school final matriculation examination equal to this. This was the first advertisement.
This was the
First advertisement.
What is the date of this advertisement?
It is, my lord,
This was of 2015.
29th May
29 May 2015 for the post of sweeper.
Sweeper.
Achha.
And thereafter kindly come to page next page 18.
18.
Page 18 Suddhikaran. English it is translated of Suddhikaran.
Uh-huh.
Page 18.
That is page
And
18 is same
English
as
there.
page 18 is same as page 14.
No, madam.
No.
That's what I'm saying. That's what I'm saying. A page 14 is the first advertisement.
That is 29th May 2015.
My lord.
Now page
And next the corresponding to the first advertisement.
that?
It is page 18, my lord.
same date 29 March.
Yes, next day it was published, my lord.
So after the first
And-
one,
and-
next one.
And the
Notification letter.
eligibility criteria, my lord, kindly page 20, count to page 20,
Part-time sweeper.
my lord.
That page.
Page 20.
Uh,
The
Again,
candidate
eligibility.
should not have passed 10 class school final matriculation examination equal to the same. Kindly recall, madam, in first page 16, there is a word, the not was not there. Not. The candidate should pass class 10. Eligibility one,
Candidate should
class
have passed class
10.
10.
10.
And
And
in
there
the addendum, it is candidate should
should
not,
not
have
have
passed.
Yes.
So you yourself were confused that whether it will be class 10 or class 8. Part-time sweeper, he has to be a PhD. Huh?
No, no,
Wasting your bank's money coming against a part-time sweeper.
kindly,
Court has passed an order. You slept over it. Then after 119 days, you filed a review application. That was dismissed. Now again delay in filing this present appeal. Your officer is playing with a part-time sweeper. We will impose exemplary cost upon you and we will say your officer will be paying that amount.
And he himself, my lord, give declaration.
What is the declaration? Very sad state of affairs. A part-time sweeper has to is before this court for 6 years. What is his salary?
Salary. 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 6,000.
And Allahabad is a pan-India concern. You are having crores of money upgradation and you will not pay a part-time sweeper 6,000. Let him die. Let him die with this.
Kindly visualize this system. He suppressed
Upon
the
visualization, we
and-
find prima
and
facie. Yes, come.
kindly count to page 28. This is the certificate issued by the school, and there
Just page,
issued by the school.
page,
This is to certify that Vikas Nayak. Well, page 28.
page 15.
28.
You showed us page 14 and page
Yes,
16.
sir.
na? Page page 14. You showed us page 16 and
14 and 16, my lord.
14.
And 6. My lord, I should, my lord,
14.
page 20 of the English translation.
So it is 16 and 20. Huh?
16 and 20.
Also. Yes, Mr. Palchu.
My lord, kindly come to the page 28. Certificate issued by the school.
Yeah, just. So you wanted, should have passed class 10 and in the corrigendum. you said
Not
should
more
not
than
have passed.
not more than class 10, my lord.
Now page 20.
28.
28. কি বলেছে?
This is certified that Vikas Nayak, son of so-and-so, was a student of this school. He passed the annual examination of class 8 in 2011 academic session. The date of his part so-and-so. And so I knew he is a good character and wish to him success.
Acha, show us in your advertisement, was there any clause that higher qualification will be a bar? नहीं वहां से करो। Mr. Pal Chaudhary, there is no statement that if you do not say the actual qualification, penal consequences will
Yes,
follow.
my lord, is there. He is a
wait.
give declaration, my lord.
Page-
If in the
What is the falsity, Mr. Chaudhary? I say I am class 10 pass. My brother says class 10 pass. I say I have passed class 8. Does it mean I have not passed Madhyamik? The commons. Suppose I have graduation degree. So to complete the graduation, I must pass class 8, na? Acha, where is your statement, chart statement, chart sheet? Yes, that will buy now. But it's the new way. What is page 37?
justice,
Mr.
my lord,
Palchu?
justice paid 38.
Page 38
38.
was a bona fide. No, you showed us page 35, na?
38, my lord.
28 you showed us. 28 you showed.
My lord, yes, my lord. And page 38 is charge sheet, my lord. Of
page 30.
my lord.
Where is your charge?
38, my lord.
হ্যাঁ, page 38.
38, my lord. Just
কোথায় চার্জটা কোথায়? Banking
following acts and
related
omission and commission are alleged to have been committed by you
employment
during the
which
course
was
of your
in
appointment.
response to the you
Yes,
submitted an
on
application
upscale wages
to
at
declare them
Thana branch of the for which you are charged under. Our bank initiated recruitment
pursuant
process
to your selection on the strength of details of
to fill up the vacancy of 22 part-time sweeper on 1 up 2/3 and 3/4 and full-time scale wage scale
pursuant to your
cost at
selection of strength of
22nd
vacancy
various branches
was
offices
issued to you intimate that your
and issued employment notification which was published in Bengali, in Ajkal and Hindi in Dainik
কোথায়
Vishwakarma.
পড়ছো? Where you are reading?
Page 38, madam, I am reading.
Paragraph 2.
Paragraph,
আচ্ছা, paragraph.
uh,
No, so we have read that.
Hmm.
Issued commutation the past thing. Starting confusions.
ক্লাস 10 পাস করা তারপর পুরো পিজি ক্লাস 10 না পাস করা ক্লাস 10
ওই না পাস করাটাতেই ঢুকছে একটুখানি
ক্লাস 10 পাস আছে
decision express করেছি। Yes, Mr. Palchodri. Now he filed his reply.
he filed his reply.
What did he say in his reply? No denial.
The reply, madam, page 40, madam.
হ্যাঁ, 40.
I Vikas Chandra, Vikas Nayak, son of so-and-so, residing so-and-so, has been appointed as PTS in one of scale wage
That is also an employee.
of Allahabad Bank. In reply to aforesaid charge sheet, I beg to submit the fact that, and my defense herein below. I have never gone through the contents of advertisement dated 29th May 2015 published in Ajkal or Dainik Vishwakarma before my appointment. My father is an employee of the Allahabad Bank. He came to know about the vacancies and about an application form which was duly filled up by me. Two, that our knowledge was minimum qualification for the job was 8 pass. Accordingly, I have attached class 8 pass certificate along with the application, my application. Three, certificate is not at all fake. Truly passed by class 8, passed class 8 examination from the concerned school. That I have submitted the said certificate with belief and knowledge and also good faith, and that the minimum qualification required for the job is class 8 first, and accordingly there is no other limit of maximum qualification. That the persons having higher qualification must have the qualification of the last year. Accordingly, it is true that I have passed class 8. That my humble submission that if a person is having higher qualification cannot be said to be unfit for an employment which needs lesser qualification. That now I have collected copy of the advertisement and found that it is in one hand it is stated.
Acha, where is your, he was terminated, na?
My lord.
Where is
After
that?
after conducting regular proceedings,
Proceeding was
he has terminated, he preferred no appeal and came to High Court, and that first writ petition was dismissed for default. He filed a recalling application. Suppressing that fact, he filed this writ petition against whom we have before, my lord.
That writ petition is pending.
That is pending means that these filed writ petition dismissed for default. He filed an application for recalling. That is pending. And
So you did not take that point in your, before the writ court.
before the report, I was not there, my lord.
You did not appear.
I was not there because of, my lord, because of the reason, only for the reason that Irad Bank and at that material point in time, there is several going on. You could not. And these are the suppressors, my lord.
Suppression, Mr. Palchuduri. There must be an intent on the to mislead. Where is that? And what is the misconduct? What was the? There was no charge sheet issued.
My lord.
No charge sheet was issued.
And regular proceedings was
Without any charge sheet.
Yes, charge sheet is
No. Page 38. What is the charge? Charge sheet কোনো charge নেই. There is a discussion. There is no charge, specific charge, that you have violated this provision of our guideline. Dekho, your aforesaid gross misconduct in terms of clause 5M of memorandum of settlement. Where is that memorandum of settlement? Mr. Palchuduri? Specific. You misleading. Gross misconduct. Dismiss for default হয়ে গেছে। Mr. Palchuduri, bring us this memo 5M. 5M টা কোথায়?
my lord, this is not, I am not equipped, so I can produce tomorrow.
অন্যায় করেছে। Yes, your other writ petition is pending.
That was dismissed for default. That is
Filed
not
any
present.
application?
No, there's no proceeding. There was fresh writ petition.
That
Fresh
you-
writ petition was
That
passed.
you said in your fresh writ petition that you earlier filed a writ
Yes,
petition.
I have stated it.
Show us. Where is your
Writ
writ
petition
petition?
does not. Writ petition does not.
আমরা বলেছি
Stated it.
আমাদের দাও আমি বলি এটা দাও
আমার কাছে নেই, কপি নেই আমার।
Writ petition.
আমার কাছে নেই কপি। আমার পিছনে কোথায় পাবো? Lord, kindly see this document, my lord. This is here from High Court record, my lord.
Huh?
From the High
Dismissed,
Court
yes,
side,
that you have annexed.
High Court site, it is downloaded from High Court site.
No, there is no dispute. We are asking in the second writ petition, did he say that the matter was dismissed, earlier matter was
Yes,
dismissed?
I know. He says, my lord, prisoner dismissed up to that. Prisoner, so far I could gather, he says up to that, the prisoner was dismissed. And thereafter recalling application, he has not said, my lord, anything.
31st of October 2018, writ petition was dismissed.
And thereafter, he has not stated any fact that whether he filed.
So forget about
Well,
that. You argue on merit. Why you are saying it is suppression?
Yes, my lord, we asked the educational qualification, and he without.
You filled up 22 posts, huh?
I have to take
22 vacancies were
I
there.
have to take up this.
You will place before us the chart of the appointees, whether all of them are only class 8 pass or not. Because you verified his certificates
Yes, my lord.
and you did not, at the time of verification also, you did not say anything. Yes. The minimum. না প্রথমটাতে ও এন্টাইটেলড হচ্ছে হুম কত বছর ধরে চলছে ওটা যে বলতে চাইছি যে ও কোয়ালিফাইড হি ওয়াজ নট কম্পিটেন্ট টু পার্টিসিপেট ডিসকোয়ালিফাইড ফ্রম ওয়ার্ক না এইটাতে বলছে
No, he's
correct he's class 10 so he's overqualified and so he could not because he's overqualified.
no, his assertion that he is class 8 pass. It will appear from page 23. Page 23.
That you have showed us.
No, I have not
Oh,
seen.
class 8, page
Class-
23, yes.
Page 23. Yes, there were we could gather from the record that we could gather that he is not class 8 pass. He has higher qualification.
The phone order is strictly getting his phone order. There was confusion in the advertisement. The same date it was. Mr. Pal Chaudhary, 29th March was your advertisement.
My lord.
And on the same date you
Yeah,
issued that.
next day it was published, my lord. Immediately.
Next day it was published, it was notified.
Yes.
Where you published?
That is, my lord. Two advertisements published, my lord. One is Bengali and one English. Hindi. Bengali is all right, but Hindi was incorrect. That's why
Bengali, Hindi, what you are saying? Your first is page 14,
Page 14, my
29th
lord.
May 2015.
My lord.
Next page 16 you are showing, you have shown
I've
us
shown
page
another
16 the qualification.
Yes.
Now the next corrigendum you issued, that is at page 18.
Page 18.
This is also 29th.
29.
So now on 29th May itself, you are giving a different qualification.
Yeah, no, no. That because of the reason that it is, well, not, we can, because of the reason that was the wrong, immediately we have taken steps, my lord. Not that we have slept all night and we have not taken any
Where
steps.
is the publication? How will the candidates come to know?
This was possible. This is part of the paper, my lord, newspaper.
No, the publication of the page 20 is the corrigendum.
Yes, well, originally is my lord, page 14. This is the original first one.
14 is the first one.
Yes, and the corrigendum is page 18.
Can do.
Because of the it is
You have not annexed that. Is the page 15 type?
it is part of the paper, my lord,
Only
newspaper.
page 18 টা দেওয়া যাবে। কিন্তু এই দুটোই সেম ডেটেড ইস্যু পেজ 20 এর অ্যাডভার্টাইজমেন্ট পেজ 18 এ
Page 18. It is also part of the newspaper, my lord.
I don't know. সূচিপত্র
Suddhipatto.
that is corrigenda.
Where was this published?
It was published on 25th.
Where?
There must be two publication, na?
Yes, my lord.
Where is the publication? How will a person, because the first advertisement says candidate should have passed 10th class, and the second corrigendum says
Should
should not have passed
No,
10th
no.
class. So he becomes disentitled due to the corrigendum.
Yes, my lord.
Now, when did you publish the corrigendum?
Next.
Where from we will come to know that you published?
Dates are 29th of May.
No, but right now I don't have the copy of the paper. That it is means inter paper. From the inter paper I could show, my lord. Newspaper. It is a part of the newspaper, my lord.
Part of
the newspaper. This is also page 2018 is also part of the newspaper.
So did you publish the same advertisement and corrigendum on the same day?
Not same day, next day.
Where is your statement to that effect?
Yes.
Page 18 টা হচ্ছে 20.
জমা দেওয়ার তারিখ ছিল 13
No, paragraph 6, my lord, I stated that the petitioner stated that advertisement published in the Hindi daily newspaper, namely Daily Vishwamato, there was some typographical mistake, and accordingly, removing such mistake, a corrigendum was published on 28 May 2015 in the said daily newspaper.
Oh. So in
copy
the
of the-
same newspaper you published?
Yes, same newspaper, my lord. It was that wrong was published in Vishwamitta, Daily Vishwamitta, and it was the next day it was published in same newspaper, correcting the same mistake.
Annex. 28 annex.
Both the paper copy of the
আঠাশ পাঁচ পূর্বে কি অ্যাডভার্টাইজমেন্ট হলোই তো 29
না ফার্স্ট অ্যাডভার্টাইজমেন্ট হলো 28 মার্চ অরিজিনালটা হলো 29 মার্চ
না ফার্স্ট অ্যাডভার্টাইজমেন্ট এইটা পেজ 14
আমাদের পেজ 14 টা অ্যানেক্স করে বাট এটা আমার মনে হচ্ছে
এইটা হচ্ছে অ্যাডভার্টাইজমেন্ট এই যে এলাহাবাদ ব্যাংক
give us your brief.
copy of them.
Yes.
So both are 29.
Have a look at page 14 and page 18. How can the advertisement and the corrigendum be of the same date?
It was published in next day, no?
We don't know.
Embedded
To us, we are open to read. I've marked it for you.
I've seen that.
Find the dates.
29th May 2015.
The other one.
Yes, my lord, same day.
So the advertise and they are ostensibly they are separate.
Separate.
The second one is the Shuddhikaran, which is a corrigendum.
Hmm.
The first one is the advertisement. So 29th May is the advertisement and 29th May is the corrigendum.
Though in paragraph 4 you have stated the date to be 28th May. Paragraph 4 of your stay application. So what is your submission? We will record that submission.
My
But-
submission, my lord,
That it was
it
on
was
the
paid-
same day it was published.
not same day, one day after it was published.
But
Maybe-
in
maybe
paragraph
date is
4,
same.
paragraph 4 you have stated that it was published at the material by an advertisement dated 28th May. This has been averred as true to knowledge.
Yes.
Jwala Prasad Shah is the petition, is the manager, na? You explain
My lord, paper, it is,
and bring the paper cuttings.
yes, my lord. I shall brought. I shall brought the two papers, my lord.
And you will take instruction that those 22 posts
Well-
were filled up or not, and any person in that 22 posts was Madhyamik pass or not. Do you have that knowledge whether any Madhyamik pass person has been engaged?
No, not personal knowledge, my lord.
Pardon?
No personal knowledge about the higher qualification, whether appointed or not. The record, my lord, can, my lord,
How you are explaining this? Because if the second corrigendum stands, in that case you are not qualified.
but my humble submission before your lordship, there is a no penal, my lord, clause in the second advertisement, as my lord submitted by my friend. No
What was
penal
that judgment? Penal clause may not be there.
there.
He
But our special bench, my lord, our the Rina Datta's, my lord, judgment
No, that is another.
also held unless rule
No,
specified.
very good. But in this corrigendum at page 16,
Yes.
page 18,
18.
they say that you should not have passed class 10.
That is stated.
If that is there, then you are class A, you become ineligible to participate in the selection process.
As per advertisement.
Misconduct we will consider later. We are trying to understand that if this corrigendum was issued, corrigendum deters you from participation since you are a class 10.
Yes.
So for that, penal clause is not required. I can fix the eligibility criteria. I am the employer. Na?
Yes, employer Kamala has a right to, my lord, fix the any, my lord,
Issue
criteria.
the corrigendum also.
Yes.
Whether it is misconduct or it is a deliberate suppression, that is a
That should
issue
be
to be
decided.
considered in a disciplinary process. They did not immediately remove you. They issued a charge sheet, they conducted a proceeding, and thereafter final order of termination was
Termination.
passed.
That was challenged before December.
What is your submission with regard?
My submission, but as per advertisement, first advertisement, there was no, my lord, but class.
Oh,
up
no
to class-
bar.
No bar. But second
Huh.
bar is there.
Then
But my humble submission will be that if there is no penal clause in the second advertisement, my participation is no bar. In
Sure.
view of the judgment of this honorable court, also, my lord,
what was that judgment?
Rina Datta to, I don't know. My lord, ever the Rina Datta's case, so many, my lord, order was passed.
I am also not
My
aware.
lord, maybe I am not aware.
Yes, my the name, my lord, kindly, my lord.
Why are you
You
in
should
court
come
without
ready.
judgment? Huh?
If you will fix the 2 p.m., my lord,
At your convenience.
well, that is my fault. My lord, I could have, my lord, brought it.
Ashok, the present appeal
Your Honor, my learned senior friend is also there. Lordship, the
You are
clarification,
saying that they have not paid the interest,
they have not,
paid
yes,
the interest on Provident Fund.
yes,
This is your content.
yes.
So Provident Fund was you are claiming the benefits pertaining to the period from up to 99,
95,
95, no?
till 95. From
90 থেকে
90 to 95.
And now they have calculated on the basis of such service. Your Provident Fund due is this much.
Yes.
Your allegation is that now you are not giving me Provident Fund without interest. That is your allegation.
Lordship, they have not even made that calculation. They have not made that effort. Lordship, I can show because the exception which I used on the last day, Lordship, which was placed before this court, Lordship, as on 1995, I had even given a statement from the Provident Fund Board. A statement was issued where it says that as on that date, my contribution was 13,000 some odd and the company's contribution was 13,000 some odd. So a cumulative figure would have been 26,000. And according to their submission, the documents which they
So
have
how
annexed,
much did they pay you?
they had only paid me 28,000.
And what upon interest, how much it comes?
Lordship, it should be around. I made my calculation, Lordship. Although it's not there, I cannot place it by way of a paper, Lordship. But it is somewhere around 1.5 lakhs because, Lordship, what has happened?
For your service of 2 years,
No, 5 years.
5 years
5 years.
contractual service.
Lordship, they were supposed to pay, they did not pay. So the interest would accumulate because that is what even in the slip it is written that the interest would be calculated
You,
from.
in the meantime, much water has flown. It is not that the money was withheld by them. They suspended you. You challenged the suspension.
No, no.
You prayed for regularization. By
Yes.
this time, the 17 years have gone by.
My lord.
Now, after losing the entire battle, can you come back and say that give me the interest for the period during which the litigation was pending?
Lordship, even by their own calculation, the slip which was handed over last occasion, Lordship, they say that as on 2011, even if Lordship,
It's very difficult.
I-
If you
I-
make
I come-
submissions by installments,
No,
it's very
I'm-
difficult.
Lordship, I did
We
not
have
get.
considered, we have passed our.
Lordship, I did not have the opportunity because this was perhaps was submitted on the last occasion only, Lordship. I could not go through it properly, Lordship, during my arguments. Lordship would kindly see the principle and the at the bottom of that document it says that statement as on.
Kalke to be mentioned. Mr. We will take it up tomorrow as to be mentioned.
I have to take instruction.
Oh, you will take instruction. Very good. Then the problem হচ্ছে আচ্ছা এই শোনো না ওটাতে অর্ডার পাস বলে লিখে দিয়েছো নাকি? Once we pass an order,
Yes,
we have
yes,
to
sir.
bring it as to be mentioned.
Let it appear tomorrow
It
as to
appear
be.
tomorrow as to be mentioned, we will recall our earlier order and we will keep it as to be mentioned on the date you suggest, so that in the meantime, you can take only this instruction as regards payment of interest. You tell us the reason, we finally decide the matter.
Only difficulty that is mine, Lord, from April 7th, 6th, I will be out of station for months together for personal difficulties. I tell you, Lord, frankly, up to 4th, I will be available. 6th is the Sunday, 6th April. Up to 4th April, I am available. Tomorrow, let it appear as to be mentioned.
What is your argument you are saying? Tell us what you want to show from this letter.
Lordship, the principal admitted is what has been mentioned, and in my exception, it is 13,000 odd. My contribution. Exception. স্যার এই ডকুমেন্টটা দেখাচ্ছে কোড থেকে আমার
আচ্ছা আমিও তো একবার
ওইটাই জজ সাহেবকে দিয়েছিলাম গতকাল।
Yes, exception to the report, what you are pointing out?
Lordship, page 13.
Yes.
Lordship would see that the total closing balance, Lordship, although it is not very clear, I'm extremely sorry, Lordship.
How many times you will be sorry?
No.
This is continuing since yesterday.
Lordship,
Yes.
it is 13,308.
Where is
That
it?
is my contribution at the bottom of the page. Lordship, it says closing balance as on March 1995. 13,008.70 paisa. Lordship,
As on
this is
1st April
31st March 1995.
94.
95.
31st March, where you are getting?
Lordship, it is
31st March, yes.
so that is my contribution, and identical would be the company's contribution. Even if we were to sum it up, Lordship, it would come to 26,000 and odd, 26,600. Lordship, as on that day, Lordship, and Lordship, what is written is interest to be calculated at 12%, which I had also shown on the last occasion per annum. Lordship, if that be so, my learned senior friend had handed over a copy, Lordship, where they show that there has been a change in the interest rate.
Yes.
Lordship, which I just handed over.
This one?
Yes.
Yes.
Yesterday I have handed over. Yes.
Handed over in court.
Second page, you
The
lost.
second or possibly the third page.
Second or third page.
Where the interest to some years it was 15 at the rate of 12%, and thereafter it came to around 9.5 and 9. Lordship, even if we were to calculate the interest, this is what my document is. Even if we were to calculate the diminishing interest as indicated by them, it would not come to a figure of 28,900, which was given by them on February 2024. Lordship, this is my case, Lordship.
Yes, February 2024.
Was
Assuming the interest which has not been paid, you have been suspended one. Your suspension writ petition was filed.
Yes.
Suspension was set aside. You were given against that appeal. Set aside that order. Your prayer for regularization was also gone.
Yes.
With a rider that they can take back money from anything.
Yes.
Now, even assuming the interest has not been paid, you have already paid on the basis of those purposes more than that interest amount.
43,000 something has been paid.
Lordship, perhaps
which
subject
have
to
been
correction.
recovered.
My other entitlements, Lordship, was of the opinion on the last day that your other entitlements may have been calculated there. The leave and other entitlements, Lordship, to which I did not make any submissions because to this day they did not, although they did pay that money, and that is also part of the record and my stay application. To this day, they did not clarify as to under which head those payments were made. Lordship, that is the only confusion. Even the report which
payment?
one is of 28,000, which was received during the hearing before the trial court, Lordship.
Yes.
The other one is 46,000 and not, which I had also indicated on the previous occasion. None of them, Lordship, bears as to under which heading those payments were made. They simply say that you have been paid. All that I want to know.
When you took the money, you didn't ask? When you were paid 43,000?
Lordship, thereafter, Lordship, even in my stay application, there are several communications which
Very
says
good,
that
Mr. Roy, we have heard you. Yes, Mr. Kundu, as regards this interest, what is your contention?
Right, today I will not
No,
accepting
this one you placed, na? Diminishing interest. So, in your exception, you must have said one line that we have paid with interest. Have you paid? Have you stated in
the
your
document itself shows, my lord.
this document?
Yes, yes.
Where do we find it, Mr. Kundu?
First page.
The amount of this is calculated at 9.5 or 12. This interest amount, is it calculated at 9.5 or at 12?
To some period it is 12 and thereafter 9.5, so far I remember. my lord. Because in 95 you are suspended.
Lordship, in their report, they have not mentioned anything about interest, Lordship, which would appear at page 6 of the report 5 by my learned senior friend, Lordship. Provident fund at the bottom of the page. Sorry, at the bottom of the page, it just gives the amount and says already have been paid to the appellant through his advocate.
That interest has been.
Kindly come to clause 4 of this letter, this one.
This, I have only one copy, Lordship, I hand it over.
You did not get time since the morning you mentioned to keep another Xerox copy.
So sorry.
Yes, kindly come to clause 4, period up to which interest has been paid to Polash Guho and the justification for cutting. The interest has been credited up to March 2011, and after that the PF accumulating standing on such and such in respect was transferred to inoperative account as per para 66 of the Employees Provident Fund and Miscellaneous Pension. So up to 2011 they have calculated and paid.
Lordship, even going by their statement, Lordship, which I have also annexed, Lordship, the interest could not have accumulated to 28,000 and not even till 2011, Lordship. Even till 2011. Because, Lordship, this is their document, Lordship, which I have annexed at page 13 to my
We'll
exception.
deal with this
My
issue
lord.
in our order.
হতে পারে না রিকোয়ারি করে দাম আপনার 13 ইন্টারেস্ট অন 1200 ইন্টারেস্ট অন 1200 টোটাল 28,000 হচ্ছে এটি বলছে হতে পারে না এর সাথে ক্যালকুলেট করেছে
এখনো হচ্ছে ইন্টারেস্টের অ্যামাউন্ট
একবার বলছে রেটটা কম একবার বলছে এটা হতে পারে
explanation. So your contention is that even if the interest as indicated herein is taken into account, it does not come to 28. So you calculated interest up to 2011.
Because he was up to, he under suspension, he remained in service till 99. because when the writ application was dismissed on 24th of June 99, and the next day, 25th, he was released. 25th of June 99. But Milord, from 95, he was under suspension. Not only he, Milord, other contractual employees, 6 contractual employees, they, because of their
He was
rough day-
removed from, after vacating the interim order, he was removed on 25th June 99.
Yes, they were released.
Huh. Now, after that, up to
Before
2000,
that, they were suspended.
very good.
They were under suspension.
But up to 2011, your calculation of interest has been this. Now, after 2011, you have sent it to a non-operative account yourself.
Because he did not apply in prescribed form. He did not apply for Provident Fund. He only applied, so far as I remember, Milord, in 2011, not in prescribed form. And he was given the prescribed form to make application. Thereafter, he made.
Acha, Mr. Roy, show us from the order that this point was agitated by you.
No.
Paragraph 6 is the amount which has been received by you, which you say by without prejudice. Please show us one line, Mr. Roy.
Lordship, this also forms part of my main prayer in the writ petition, Lordship.
Got it afterwards.
এটাকে টু বি মেনশন কালকে দাও। You come ready and show us the provisions. We will consider on that. Mr. Kundu, you have stated in this letter that you have also sought for an instruction from the EPOFO office. That last page.
Last page.
Regional Provident Fund Commission.
Well, what is the amount remitted
from November 90 to June 90. এটা তো 90 থেকে 99, এটা হচ্ছে কন্ট্রিবিউশন, এইগুলো এইটার রেকর্ডটা হচ্ছে so that is so you have said requested to arrange to provide the month-wise contribution for the period from November 90 to June 99. That is during the period he continued. Now, if that is so, then how the CPF amount is, your share is being calculated to be total 13,217 during the period from, this is for which period?
Must be up to 95 before suspension.
Monthly contribution. This is before
Suspension must be before suspension because from 95 October, if I remember, Lord,
what was the period during which he also contributed, you also contributed?
must be Lord
That was March 20,
95.
সেটাই কি এই টাকাটা? এটা তো so this letter is still awaited.
Yes.
Reply to that is still awaited. Now,
I
when
did
will
not get any reply from them. It has been sent to them, but no reply has been given by my client.
so how long you will not be there in court?
Up to 4th April.
After that,
At least 1 month together. After summer vacation. This
now
is my
what is
personal-
your answer to this? Your entitlement was November 90 to November 99. You have shown us March 20, 1995 deduction of 13,000 up to March 95. That is up to the date you were in service.
Yes.
So this 13,000 and their 13,000 was added. This is up to March 99.
95.
That is the closing balance, although
Closing balance.
Lordship,
So now you are saying
Lordship,
that
may I kindly indicate, since I continued service till October 1995, I had also made contribution to that extent. This I had continued in service, undisputed service till October 19th October 1995. That is my case, Lordship. Till that period, Lordship, I have also made my contribution towards Provident Fund. They have also. This statement is an indication, Lordship, that it could not have been anything lower than this. Because as on 31st March 1995, Lordship, because there is the closing date, closing balance, this is the amount. So even if I were to calculate my contribution and the company's contribution and include interest on it, even if I were to admit, although I do not admit, even if I were to admit that
sir,
2000,
where is that case made out in your writ petition?
Lordship, in the writ
On the
petition,
very first day we are saying us
Nothing.
that you show us that
Lordship,
this
in the-
Provident Fund calculation, you have up to this 95, I have paid so much of
Lordship,
contribution.
Lordship, with the greatest of respect, Lordship, in my writ petition from the press, what I find is we had
Give me with interest.
we have requested them that you pay me all my service dues, including Provident Fund with interest. They did not come up with any calculation, Lordship. This is perhaps for the first time they came up with this calculation, which was handed over on the last occasion. Even in the trial court, Lordship, they simply came up with a demand draft. Lordship, today I had handed over 3 orders. In the first order, it records that they have come up with a demand draft. In the next order, it says that I have accepted without prejudice. To this day, they have not made any, and Lordship.
Come to your prayer, page 61.
Yes, my lord. My lord.
By making payment in respect of outstanding claim, notice pay, retrenchment, salary, leave salary, annual performance incentive, pay revision, along with interest.
Lordship,
There is no prayer for which you are just now saying.
Lordship, page 62, Lordship.
Yes.
Provident fund along with interest thereon, pay revision along with interest thereon as applicable under the Interest Act. Lordship.
Provident fund.
Yes, ma'am.
Yes.
Lordship,
Now, where is your statement that you up to 95 you have paid this much contribution?
Lordship, that was perhaps I do not know, Lordship. That was
So
not
there was
disputed.
not there.
Lordship, that was not disputed because in the writ petition, Lordship,
where do you have said? In the writ petition, where you have said that my contribution to Provident Fund is this much and this is lying with the authorities.
Lordship, in so many words, it may not have been
No,
stated.
no, please, so many words, less words, no. You have referred to that in paragraph 13 also. Only on account of paragraph 13 of your writ petition, you have said, by advocate's letter, petitioner wrote to senior accounts wherein filled up prescribed forms in reserve on account of his unpaid provident fund and gratuity had been enclosed. Where is that? Annexure T4.
That is there.
Come to page 68. There also you do not say. I, Palash Guo, request you to release my dues of provident appointed such and such, continued in such and such, terminated in spite of severance of long till date. I have not received the amounts. I am in service. I am requested to do it. You did not say, Mr. Roy, because of this reason that you were involved in multiple litigations against your employer.
Lordship, before the trial court, Lordship, all that
was. Show us, Mr. Roy, that up to 1995, as you just now said, that my contribution was with you and this was my deducted amount.
Lordship, I had annexed also my pay slips, Lordship, to this stay application.
We are not to. This is from pay slips are from
Lordship,
up to December 92.
Yes, Lordship, I spoke to my clients. He could not lay his hands on all the pay slips. This is, Lordship, the contribution which is there with the company, Lordship.
All right. Yes. Now to be mentioned, if I sorry, Mr. Roy.
Let some order be passed for my as well.
No, matter is not in the list what order he will pass. He requested that he will request Mr. Kundu.
So your lordship had hard so much time.
Yes.
Oh, Mr. Dhol, come tomorrow. Where is your brother? এই কালকের কি 12টার সময় কিছু ফিক্স আছে নাকি? Ask, where is Mr. Chatterjee? Day after tomorrow, Friday কি কিছু আছে? 2 PM পার্থর সাথে বেঞ্চ আছে। Friday 2 PM পার্থর সাথে তো বেঞ্চ আছে। কবে বলছো? শুক্রবার।
হ্যাঁ, ওটা তো হবে না কারণ
নেই। আচ্ছা 28 তারিখ কি পার্থর সাথে বেঞ্চ আছে না 2টোর সময়? এটা ওই কন্টেন্ট ম্যাটার ট্যাটার সব বললাম যে পরের সাথে
আসলে আজকে একটা 13 নম্বরে 10 ছিল ওটাকে অ্যাডমিট করেছি আর এটা নাই করেছি
ওটা ছাড়ার আগে আমায় দেখো।
যদি না
tomorrow you have problem?
my lord today I have made one matter
Very good.
not today for this matter my lord. Tomorrow it will be called on.
এটা কি শুক্রবার দিনকে লিস্টে দাও?
Yes.
We have extensively heard now. We will
Yes.
hear him and finish it off.
My lord, I am also for that my lord I have enjoyed that matter my lord, that is also applicable. My lord, I will come on Friday my lord, let us try.
Let it be in the list
Yes.
on Friday. Catch hold of Mr. Chatterjee and come to us if it is not reached. If it is not reached on Friday, tell us,
My
remind
lord,
us.
my lord.
Yes. ওই 12টার সময় কিছু নেই তো 12টায়? Yes, Mr. Sami.
This matter loss is taken up previously. So Justice Mitru was not there. Other division bench was there.
Yes, yes, yes. Oh,
It is my maiden appearance before Justice Mitru. It was taken up by other bench.
that it
Yes.
will be a joyful maiden appearance. তাই না? We do not. If the order goes against you, it becomes.
Even then.
Oh, even then. Very good. Yes, please.
Now, this is a matter that, in fact, we challenge them that order of transfer.
Yeah, just. দেখো না এই ইন্ডিভিজুয়াল সার্ভিস টার্ভিস জন্য নোটটা থাকলে দাও একটু নোটটা করতে শুরু করো। Any list of dates you have filed?
No. Written notes to have that.
Earlier, did you file any list of dates, etc.?
No.
Achha.
We have
You have
prepared it.
prepared any list of dates? Sure.
But sir, I have prepared a list of dates regarding showing his conduct, how he was guilty of.
Give a copy to him. Nahi na?
My lordship, kindly pardon me because today itself it was prepared. There may be a typographical mistake, your lordship. But on the last occasion, lordship has clarified that no further adjournment will be granted.
Yes, yes.
Lordship, I
You
was.
want to finish it off?
Yes, lordship.
Because
So there may be a typographical mistake. Kindly
later
pardon
all
me.
right. Yes.
That initially our challenge was order of transfer. That was issued on 11th March 2016.
Yes. Page.
at page 155.
Yes.
First.
At that time you were working at which branch?
At SME Finance. SME Finance.
Where do we find that? SMEFB.
Yes.
Branch.
SME Finance branch.
Achha. You were
Transferred to
Hmm.
ARM branch, Kolkata.
Both are in Kolkata.
Both are in Kolkata.
Both in Kolkata. Both in Kolkata.
In the same premises, ground floor, first floor. I have gone through the record.
All right.
ARM branch was situated in the first floor. Because of exigencies of March ending, he was transferred there temporarily.
This is the full form of ARM.
But see, in my pleading itself, affidavit in opposition.
Full form of ARM.
ARM branch, Assets Recovery Management Branch.
Yes.
Now at 157.
And the SME full form is?
Small Medium Enterprises. Small Medium Enterprises Branch.
Yes.
My challenge was in that writ petition.
That is asset recovery. কি বলবো?
Asset recovery. Recovery.
You made an application on 29th March regarding your illness. What did you say in that 29th?
29th March.
You sought for any leave?
Yes, that leave was sought for because of
Show
my
us that
illness as well as
29th.
my wife's illness that is there. Before that, just
Please show us the 29th March.
29th March.
Is it page 134? No, this is 23rd February 2016. 24th February. Ask your juniors to find out that page. Yes, you proceed.
Now at page 157. Is the screenshot of the website data. So far my service is concerned. This I have annexed to show that entire service request was transferred to Recovery Branch, Kolkata. This dashboard and in the middle. So this is
service records were transferred to that branch.
To that branch.
Yes.
To demonstrate that service transfer was effected. Page 58 also. Recovery branch.
'58.
Yes.
Yes, 158.
158, yes.
So
Kindly
what is
see.
the date?
Anupam Dash, the date. It was printed on 19th July 2018. As I can see from the print copy at the top, left hand side. 19th July 2018, it was printed. And kindly see that Anupam Dash, branch is Recovery Branch, Kolkata, and branch code Zonal Office then status right hand side active. Right hand side column active. Therefore, transfer was effected.
Yes.
Now, my lord, can you transfer that? Page 160. My allegation was, since I was made protest against so much of corruptions, that's the reason I was transferred. Now, my lord, can you take up page 160? Page 160.
Yes.
Now, this is another transfer order by the same branch, SME Finance, Kolkata. If I have been transferred to ARM, then my second transfer would be by the ARM to any other branch, not by the SME job transferee branch.
Your page 155 was 11th March 2016.
Yes.
By which you had intimated you have been transferred. Now, what is 160?
160 is subsequent transfer order. 1st July.
What is, please explain page 155. At the top line, it is 11th March 2016. When was it communicated to you?
Well, this is the date of communication. Order of.
How can this be? Because your request letter was 29 March.
No, let kindly see the email from so-and-so on Wednesday, 30th March,
So
2016.
what is that 11th March date given there?
That is a reference, possibly. That is subject of the text mailbox.
So 30th March, that was issued.
That
now
was
page
issued.
160 is 1st July 2016.
Yes, subsequent.
Yes, why you are showing us that?
Because I have shown at page 158 that in terms of page 155,
it was records were sent to the
transfer was given effect to. Page 158, last column, status is active.
Very good, you proceed.
Now, there was no occasion for the SME branch, rather the transferee branch from which I was transferred to ARM branch, to issue or communicate any order of transfer, because I was not there in the SME branch. But I'll demonstrate from their other records also the malafide. Now, at least from this document, I can show that SME branch, SME Finance branch, Kolkata, on 1st July is communicating a order of transfer to Shiliguri. What they have justified in their affidavit, not there in the list of dates, just now I have seen, that first one is not a transfer order. Though they have in their...
Proceed. Then what happened?
I challenge this order of transfer on the ground of malafide.
Which order? Page
Both.
160.
Both.
Yes.
Now,
your contention is on the after the transfer order has been effected to the ARM branch,
if any transfer
you again issued a transfer order to me
by the SME branch.
Yes. So both challenged.
Both challenged.
Yes. What did the court say?
That writ petition was some pleadings was missing, amendment was allowed. In the meantime, they issued charge sheet for my absence.
You were absent since 29th March.
29th March, yes.
So absent since 29 March.
And in the chart sheet, if you kindly takes up page 79.
Chart sheet.
At page communicated through email at page 79.
Page 79. Yes.
And 79 is the email by which charge sheet was communicated. Page 80 is the memorandum of charge sheet.
Yes.
The challenge in this appeal is this charge sheet and consequential penalty.
Yes. Yes, yes.
Now, let again kindly see at page 80. This charge sheet is being issued by the Zonal Office, Kolkata.
Yes, that is the head office.
Now, that is the Zonal Office. Now, in terms of the rules, it is the Assistant General Manager who is the authority competent to issue charge sheet. Here also the Assistant General Manager, Kolkata, has issued the charge sheet. But the Zonal Office, so far the order of transfer is concerned that I have shown, is Zonal Office, Siliguri. Therefore, the competent authority would be Assistant General Manager, being
How,
the
you
disciplinary
have not
authority,
joined-
Siliguri.
You have not joined Siliguri.
No, I have not joined.
Then
But
you have not accepted the transfer. Anyway, proceed. What did the trial judge say? Let us see.
Just few more facts, and I'll come to that trial just.
Yes, we understood that your contention is you have transferred. It would not, this is without jurisdiction. It ought to have been issued by
Is
the
one.
concerned zonal.
First submission.
Hmm.
That even the charge sheet issued by the authority,
yes,
admittedly from the office from which I have been transferred to other office. Therefore, the authority competent is the authority where I have been transferred, because they are taking into
Please
consideration.
don't repeat now. It will take time. Now let us proceed. We understood. We took note of your point.
Yes, page 82 is the charges. Now, Article 1, 2, 3, 4, 5 all are relating to unauthorized absence. Nowhere they have said this is willful unauthorized absence. This is my second point. And I'll be relying on judgment of your lordship's own judgment.
Yes.
Now at page 85, imputation of charges 4 and 5 I want to place, because these 4 and 5 records my transfer. And similar the first line, Article 4, transfer to ARM. Page 85. And then again, transferred to Siliguri Zonal Branch. She did not join new place of posting despite order of the Honorable Court directing him to
Where
join.
you are reading?
Not Article 5, imputation Article 5.
Yes.
Yeah.
Transferred to Siliguri.
Siliguri, so and so
Did not
letter,
join.
did not join his
Further-
new place of posting in violation of the said order. Further, the Honorable High Court passed an order dated in the matter of writ petition number so and so,
on 23rd
directing
August.
him to join new place of posting within 10 days of the order of High Court. Sri Das did not join in his new place of posting in complete disregard to the order of the Honorable High Court. And then, what are the allegation? The acts, omission and commission committed by the said Sri Anupam Das are in violation of Regulation 3133 of this Regulation 1976. So, this is the charge that I have violated these regulations. I will be demonstrating that I have not violated any of this regulation.
No, you take us to the order impugned. Then you argue. Your arguments you must have advanced there. First show us that 23rd August 2000.
418. 418.
23rd August.
Impugned judgment.
No, 23rd August order. 23rd August 2016.
Oh, not page 70.
Did you find out that page of 29th March?
It's not
Your
there in the
request letter?
not there in the record.
Yes, page 70.
अरे ना रे बाप. Shit. Impugned decision. Penalty order. Penalty order. Oh, just a second.
Yes.
192 is the appellate order.
193.
192.
No. Show us the
No,
impugned order.
90.
Huh?
90.
90.
Yes. No. Penalty that was imposed in the. This is the penalty disciplinary decision of the disciplinary authority.
No. Take us to the order impugning the appeal.
Oh.
That will give us an idea what are your
418.
Yes, place it.
That court records my submissions. But if you also kindly take some at page 420.
Yes.
My contentions was recorded in the middle. Being aggrieved, the petitioner has filed the writ petition.
Yes.
Then the primary contention of the petitioner is that the charge sheet, inquiry report, findings of the dismissal authority and the appellate authority does not disclose any misconduct within the meaning of regulation 3133 of the conduct regulations. This is one of my points I have taken in the single judge. Then next para, he contends that there is no allegation in the charge sheet that his absence is either willful or deliberate. This is the second point I have taken. Now on the next page, 421, first, second, third paragraph, petitioner has mentioned in detail the reasons for his absence in the appeal preferred by him before the appellate authority. He argues that none of the averments made in the petitioner has been disputed by the appellate authority. As such, his absence not being willful and deliberate ought to be condoned, and the charge of misconduct is liable to fail.
Yes.
Then one paragraph left, the petitioner submits he could not take part in the disciplinary proceedings as the notices were not received by him. He submits that his employer was well aware of his email number and the documents ought to have been sent through email. Non-service of documents relating to disciplinary proceedings, including inquiry report, has caused prejudice to him.
Yes.
Then the petitioner contends that respondents proceeded in predetermined manner. On the very day of issuing charge sheet, the employer had declared him to be on unauthorized leave because the charge sheet records unauthorized leave. At page 422, first paragraph, according to the petitioner, none of the documents relied upon by the employer were proved by the witness. Regulation 6.
Mr. Shamim Ahmed, we will not go into intricacies of evidence. You show us the wrong in the order. You have shown your arguments, take us to his findings.
Now at page 431.
Yes.
To answer, has answered my submission.
Yes. You place that and tell us what is the inference. We are in judicial review.
Yes, lad. But to be very precise, my submission is this is not willful and deliberate absence. One. Second is the order is without jurisdiction. and the charge sheet is vague vis-a-vis the regular. I have not violated any of the regulations that they have referred to. That this is this. That's all my submission. Now, 430 last paragraph. The court records my observation. Petitioner was an officer of the Allahabad. Service of the petitioner was transferable one. The petitioner on so-and-so date fell sick and had to be administered. In the second paragraph, I don't read the entirety. It appears from the records remained absent for 81 days between 27 November 2015 to 15 February 2016. Then my last paragraph, the observation. Court is deciding whether it's willful or not. It appears in the instant case, the petitioner absent himself from work without obtaining prior permission of the competent authority for days together. Petitioners forwarded a message via email in the morning intimating that he would not be able to report to the duty as he was not feeling comfortable. The discomfort of the petitioner was not backed up by medical reports.
This is referring to which representation of yours?
In fact,
is that 29th March?
There are several representations on every occasion that I have emailed them.
No, you have not shown us page 155 letter was issued in response to your representation of 29th March.
That is irrelevant.
Unless that is there, you cannot show us. Find out that letter. Yes, now this observation of his lordship was on the basis of 29th March letter.
No, there are several email that was communicated seeking leave.
Email was communicated that was
because
refers to an initial period from 27 November to 15th February.
Yes, that is the entirety period. Up to the charge sheet.
No.
That is up to charge sheet. Charge sheet was issued on.
Charge sheet was issued on page 79.
Yes, 15 September 2016. Total period I have count is more than 81 days. It is 351 days. Because if you lordship takes up charge sheet,
where is the charge sheet? You said
page 84 of the charge sheet. Can you take up page 84?
No. Why 84?
84 is when period has been mentioned. Charge sheet.
84.
84. In the box.
Yes.
18 November 2015, one day, 24th. Then this period of 27 November to 15 February. And then 28th February 2016. Then 23rd February 2016 till date.
Till date means what date?
Up. Issuance of charge sheet.
15 September.
Yes. Now that I have calculated by 351 days.
সাতাশে নভেম্বর থেকে 23 সেপ্টেম্বর 27 নভেম্বর থেকে 15/2 নিশ্চয়ই 16/2 জয়েন করেছে 16, 17, 18 করলো 19 করলো 20 দেওয়া হচ্ছিল এবার চার্জশিটটা ইস্যুডের
This one has also mentioned.
পাইলেন 3/12/2025 15 চিঠি দিয়েছে
Own contact.
Yes.
Now, my lord, I have taken the point of willful or deliberate. Now, my lord, that has been answered at page 433 in the middle.
Yes.
The petitioner has challenged the same as according to him, the regulation dealing with the absence was not specifically mentioned in the article of charge issued to him. The charge sheet mentioned violation of 3.1 and 3.3 of the contract regulation.
Why did you say the period of absence was not mentioned? It was mentioned.
No, period of absence is mentioned. Absence is undisputed. But this absence is deliberate, willful. These words are missing. Unless the charge is there, willful absence, then there is no misconduct. Mere absence is not misconduct.
Yes.
Now, the court has answered, however, the regulation 24 relating to misconduct has also been mentioned in the article of charge. That is the answer. Regulation 24 of the regulations mentions that a breach of any provisions shall be deemed to constitute misconduct punishable under regulations.
Where is 3.1 and 3.3?
Yes.
কত নম্বর কথা 19
Yes. Yes.
3.1 and 3.3.
Yes. Yes, yes.
Amulet, court refers to regulation 24. Acts of misconduct, page 19. A breach of any provisions of this regulation shall be deemed to be to constitute misconduct. I'm going to state with him that I refer to my judgment that I
Judgment will come. Finish up. Next. Regulation 20. Then that was one. Now regulation 3 mentions now.
Now I'm going to kindly change some page 433, last paragraph. To fill up the gap,
Yeah, just.
Due diligence. The one 3.1 and 3.3 vis-a-vis the charges framed against me has no relation.
Why no dilation? You had no diligence in doing your service.
That is not the charge, my lord. Can you see?
3-1 is diligence.
Can you see the charges?
Charge is 3-1. Your
No.
conduct shows indiligent in
Not
service.
whatever there in the charges, charge that is there. We cannot develop it. Now, my lord, the imputation of charges and the, my lord, regulations refers to, my lord, has barely any relation, my lord. Can you see, my lord? What is the allegation in the imputation of charges? May I read, my lord, the first one? Article of charge, article charge
Now
1.
we will go into the reappreciate the.
No. I am not even saying that.
To answer our question, 3-1 speaks of diligence. Speaks of diligence.
They never says that I am not diligent.
3-1 has been applied.
No, they have never said in the charge sheet.
In view of your conduct, they say 3-1-3-3 violation is there. The judge adds to it regulation 20.
If you listen, it's the understanding of the court, then I have nothing. My understanding that the charges is unauthorized absence. There is a specific provision. If you listen, kindly turns to regulation 13. There is a provision regarding absence. That was not the charge.
Table 13.
Regulation 13. Page 12 of the blood compilation.
Yes.
No employee, no officer, employee shall absent himself from his duty or be late in attending office or leave the station without having first obtained the permission of the competent authority. Provided that in case of unavoidable circumstances where availing prior permission is not possible or is difficult, such permission may be obtained later subject to the satisfaction of the competent authority. So this provision is there. Not that the 3-1 and 3-3 is the only provision available to them to frame the charge sheet. That's not that. I'll come to the decisions of the court, Supreme Court.
Your allegation is you are in unauthorized absence. Unauthorized absence as per the regulations is without prior permission.
My first submission was, whenever they say unauthorized absence, they have decided this absence is unauthorized.
They have to?
They have decided that absence is unauthorized.
Naturally, you cannot prove any document to show that you have given permission.
That is, if I am understood correctly, the procedure is you have to give the allegations, you have to reduce the allegations against B. I'll be given a chance to rebut by filing my statement.
No, you show us. We are asking you that any explanation supports your absence during that period.
I'm coming. My submission would be that Lordship is not reappreciating evidences.
Right.
You
are saying that the
decision-making process we have challenged.
Your argument is that unauthorized absence has been recorded in the order in the charge sheet. When can an absence be unauthorized? Supreme Court says that it has to be willful.
Has to be decided ultimately.
Will have to be willful.
Willful? And even they cannot record unauthorized. Immediately they say unauthorized, then nothing remains to decide.
So how they will say it is authorized?
They will say that from this period to this period, you were absent.
That is the imputation which has been given.
No, they have said, that's why I'm saying, they have said unauthorized.
That is not proper. Same branch, difference of floors, and matter goes on. You are so egoistic. I will not go. Mr. Ahmed, malafide will arise. There are no particular instance can be.
If I want to succeed in the matter, I have to satisfy Lordship's conscience. That I know.
Yes.
That I know.
Yes.
But before that, I'll try to. Before that, whatever on the records, I'm trying to demonstrate with Lordship how they have proceeded.
Admittedly, he's throwing the challenge. No? He's saying, yes, I was not present. He said that. Yes, next.
Kindly transfer how the the single judge my lord, has dealt with the my lord, submission.
Yes.
Page 436. And I'm trying to my lord, cut short and
No, please come to 434, last paragraph.
434. Yes.
Where is the expression prior permission appearing in the conduct regulations?
The expression prior permission as appearing in the conduct regulation has been given due importance.
We do not find it. Prior permission in regulation, we do not find.
No,
Sure.
no, regulation 13.
Regulation. Huh?
Regulation 13 says you have to take prior permission in case of emergence.
What's regulation 13?
13. That was not there in the chart sheet.
Yes.
In case of emergency, unavoidable circumstances, the leave can be granted subject to the satisfaction of the authority.
Permission to be obtained.
Permission
Yes.
to obtain.
Then
Let's page 436. Last paragraph.
yes.
Petitioner contends that as there is separate regulations dealing with absence from duty, regulation 13 of the conduct regulation bank ought to have been invoked the same and thereafter proceed accordingly. As the bank did not invoke regulation 13, accordingly charge of absence from duty cannot be attributed to the petitioner. It has further been submitted that the petitioner all along provided the reasons for not reporting the duty to his superior. The absence was not willful.
Yes.
And is in absence of a finding that the petitioner remained willfully absent from duty, the period during which he did not report for duty ought not to have been treated as unauthorized.
Yes. Now, where is the finding of the court?
Discipline authority.
No, the court finding. This is discussion on your submissions.
No, yes. But this is the finding of the court. No, this is not the content.
Petitioner contents.
Contents and then court explain court's view.
No, later on she has not gone into that.
It is the contention of the petitioner. Your Lordship. It is the
And the
contention of the
very next
petitioner
paragraph,
recorded by the Honorable.
very next paragraph.
You kindly come and place. I think it starts
This
from page-
next paragraph is the important one. Because next paragraph concludes court observation. So far, willful is concerned. Page 437.
Yes. Which paragraph?
437, first paragraph. The Supreme Court in the matter of so-and-so, paragraph 23, has laid down that the view expressed in case of so-and-so has to be restricted to the facts of the said case. Regard being had to the real proposition, the nature of charge leveled against the employee, and the material that had come on record during the inquiry, it cannot be stated as an absolute proposition of law. And whenever there is a long unauthorized absence, it is obligatory on the part of the receiving authority to record a finding that the absence is willful, even if the employee fails to show the compelling circumstances that remain absent. The said decision has practically denuded a precedential value of the decision in so and so. So, this is the observation. So far, willful is concerned. 436 and 437 is the observation of the court. So far, my submission of willful is concerned. Now, if you kindly takes up.
No, this is in your favor. It cannot be stated as an absolute proposition in law that whenever there is long unauthorized, it is obligatory on the part of the decision to record a finding. Oh, the court says that no such recording is required.
No such recording is required.
Recording is not there.
Because I have shown to the single judge that even the disciplinary authority did not record that findings. If you kindly takes up the decision of the disciplinary authority with this.
Very good. No, it is admitted then.
Admitted.
Yes.
Then the next paragraph is I have taken how the document is proved in a proceedings. None of the documents were tendered by the this judgment I'm not citing. This judgment I have shown to the single judge to demonstrate that the recipient of the document or the author of the document has to tender the document to prove the document.
Why the management witnesses were not examined?
This was not now. Now.
There was no examination?
No. By the person who is the author of the
Author of what?
Of the document. This is a judgment for the proposition that either the author of the document or the recipient of the document can tender the document to prove it. Page 438 court records that observation.
It was an ex parte inquiry. You did not participate.
No, I was not given any notice. Because they have they have served the charge sheet through email. Because the change of address, that is their case. That the address that was available with the bank, they have made postal service there. But I have changed my address. I did not update my address in the bank. But all the communications, including transfer order, charge sheet, was made through email, except this one, the subsequent communication up to the penalty. Again, the penalty was communicated through email. Order of transfer, charge sheet, and penalty was communicated through email. And the rest where they have posted. So my case was that they have deliberately did not.
Where you have stated that? That was not your argument.
Yes, that was my argument.
Where it is. Now first finish off with this. Expired documents relied upon the management were merely tendered and not proved. Now what is the finding given by the court?
438, first paragraph.
Yes. In reply to that, the respondent submit such and such. Where the records comprising of attendance register, letters, or great event, there is no requirement. Oh.
And the next paragraph, court only records only one line, that there are evidences galore against the petitioner. That's the last line court has observed. Whether that can be treated as evidence for the purpose of disciplinary proceedings, that has not been considered. Whether these records can be considered as evidence for the purpose of disciplinary proceedings. That's my case. It's a quasi-judicial proceedings. Then,
what did you say? Order of transfer and till the charge sheet, all communications were?
Up to charge sheet was communicated through email, and then again the penalty was communicated through email.
And the other documents were sent.
They have said that they have made advertisement, they have made through post.
It's very unbelievable.
They have shown few news cutting that the advertisement made in the
yes.
Now, there was a statutory appellate authority. So, I availed that authority. Now, my next submission would be there is no independent finding of the statutory appellate authority. I'll show to that your lordship and the findings of the single judge at page 439. First and second paragraph is on that.
Yes.
Respond rely on judgment delivered by so-and-so. Wherein the court has held that when the punishing authority agrees with the findings.
No detailed order is required. Yes.
Then next paragraph.
If
This-
disagrees, that is not applying here.
No independent finding of the appellate authority.
No,
Independent finding of the disciplinary authority as well as the appellate authority.
no, there has been no disagreement.
There is no disagreement.
Hmm.
So far, the statutory appeal is concerned, my additional point is, I have specifically mentioned the grounds of appeal. That only 1 to 4, if I'm not mistaken, I'll verify that grounds has been addressed, and after the appeal, the appellate authority takes a decision that inquiry report should be served, and only after the appeal, the inquiry report was served on me. In terms of the direction of the statutory appeal authority, the inquiry report was served on me, not before that. These findings was different from, this is the only finding made by the appellate authority. And other grounds has not been considered.
No, then what happened? The inquiry report was
served on me.
Yes. Then you gave any reply?
Before that
Nothing
punishment was
done.
given.
So it was an ineffective order.
Ineffective. Now, my next submission was that in any event, the penalty imposed on me is disproportionate. That is
before that you show us your representations which you made explaining your absence. Where is that?
First letter.
Uh-huh.
First letter. 29th.
No, you were absent for total 351 days. So your first transfer order was on March 2016.
Yes.
No, March 2000. Transfer order is 150. 11th March থেকে দিয়েছে।
Entire period টা টাকা দেওয়া হচ্ছে।
পিরিয়ডটা দিল from 18ই নভেম্বর। ইয়েতে থাকে
না তোমাদের চিঠিগুলো টাকা দেওয়া আমার।
ওর
অর্ধেক চিঠি নিজে নিজে করেছে।
আর চার্জশিটটা ইস্যুড হলো গিয়ে তোমার 23rd August 2000. No, sorry. Charge sheet was issued on 14th December
97. Page 97 onwards. This is the letter
September 2016. আর ওর অ্যাবসেন্সটা হচ্ছে 18th November 2015 ট্রান্সফারটা কোথায়? 27 নভেম্বর থেকে 15 তারপরেও কিন্তু চার্জশিট ইস্যু হলো 15ই সেপ্টেম্বর। Was the explanation as regards your absence? That is pertaining to the period from 27th November to 15th February. That is the 81 days period and another 84 days period.
I have to,
15th of September, charge sheet was issued.
Against the charge sheet, but I have never used any my defense. Therefore, there is no
We
explanation.
are asking you.
That I have annexed few records that I have made communication at page 97. You can find.
That way it won't help you. You have to bring a chart and show us your argument is that my absence is admitted, but it is not willful.
Yes.
This is your entire.
And with all due respect, that would be I can ask my client. Okay.
Page 97.
301 থেকে একটা explanation আছে, but পুরোটা নেই। তাতে এই পাতাতে
2015
তো এটাই একই জিনিস।
not a person interested in the work. Why will a person remain 384 absent?
Now,
Can you
because,
leave
that
High Court
because of
for-
my pendency of the writ petition. That because of pendency of the writ petition.
You did not join in spite of High Court's order.
Now, High Court's order that I have annexed, that I have obtained the plane ticket. Thereafter, my wife was ill. It was immediate surgery was required, but he was admitted to hospital. That I have annexed.
You could have went and dropped a letter there that my wife is admitted. You did not do that.
The remedy available was that I could have asked for clarification from the court, and because there was a direction.
So that goes against you, huh?
That goes against me. That I
Once
cannot,
the court
whatever is there, I cannot develop that. But all that I'm saying,
that shows you are not inclined to continue in service. Can you imagine 2024 era, a person without service, death penalty imposed? That will be your argument. Disproportionate punishment.
in fact, I am off the record, I am doing this matter. In fact, after single bench, he is not. In fact, during even single bench pro bono. 5 years old child is there. Nobody is there. And I must say to your lordship that this man is rigid to his decision. Very much rigid to his decision. That I have seen. I made a request to him, but I have not. According to him, that he made protest against the corruption. So he'll not bend on any pressure.
What he is doing presently, Mr. Ahmed?
Nothing. Nothing.
There is some mismanagement.
Not to come with his daughter in court. No, today we are not going them to go out, but this is not the procedure.
I understand. Psychological.
And we also understand the difficulty you are facing. We also understand. That is why at the instance of Partho's সাথে বসে বলেছিলাম
64 আমার অ্যাপিলে ডিলের কিছু
document that you leveled corruption charges against your officers?
I have.
Your client, you just now said na that he was trying to prevent corruption in office.
No formal letter has been.
How long did he serve till the issuance of the charge sheet? 2015 absence. When did he enter into service?
2011. কবে ফার্স্ট জয়েন করেছেন সার্ভিসে? First clerical since 2011 he served.
He is a cashier.
He was initially as a clerk. He was promoted to that post and thereafter.
Post of cashier.
Post of junior management.
Assistant manager. All right. And your last is disproportionate. And page ওটা কোথায় দেখালেন তুমি তো? Page 150. Page 150 দেখালেন না leave it explanation টা?
But I have given explanation. It's the only document I have that
Page
apart from
97.
communications. 164 is the appeal against the penalty.
No, you have page 97.
That is the letter communication to them. But so far as the charge is concerned, vis-a-vis the absent, my only documents available is 164, the appeal, statutory appeal that I have made. There I have given an explanation of my absence. So far the charges is concerned.
That is which pages? Please
Page
tell us
164.
your explanation.
Page 164 to up to page 189.
Casually medical, casually casual. 27 till date, 15 Dismissal. Yes, and last argument is disproportionate.
Yes, disproportionate.
Yes, yes.
Now, let
Anything else, Jason?
yes, ma'am. And if you let's say, can it takes up their affidavit?
Huh? Affidavit, their affidavit.
Yes, ma'am.
Yes, that is at
203, Your Lordship.
page 203.
203.
Now, let kindly turns to let
In your regulation, penalty clause is which regulation? Page 203. You are showing us what?
Now, kindly takes up the jural part.
Page? No, we will go to that one query. Why didn't you obey the court's order? This 23rd August 2016.
That kindly takes up
This writ petition was challenging the charge sheet and the proceedings, no?
that page 72.
No, in the writ petition, challenge was only the transfer orders, no?
Previous writ petition.
That is WP 16506, page 70.
16506.
This was disposed of. Huh?
In view of the decision taken by the statutory appellate authority. Since they say
Where is that order? Oh, Tanix Court. এটা কি? হোম অ্যাপিয়ার না না তারপরে এটা ডিসমিস করে দিল অপোজিশন সাবজেক্ট ম্যাটার ওয়াজ ট্রান্সফার্ড দেয়ার
subject matter was transferred. Since I was
concluded after initiating after decision proceeding was initiated. So challenging that you filed the present, that you filed which year?
Against the penalty I have filed in 2018.
That is after dismissal of that matter. After dismissal of
After dismissal of this one, yes. I have to challenge afresh. It was affirmed on
despite his efforts in that
20th July 2018. 20th July 2018, the writ petition was affirmed.
28. 20th or 22/8?
20.
20 April 2018.
20/7/2018.
Acha, acha.
July.
20th July 28. That was on 29 June 2016.
Immediately after that?
But the petition became infructuous because you were dismissed.
Yes. That was the findings.
Yes.
The penalty provision is that oh, there is separate rules, but not in the compilation.
Separate rules?
Yes. Discipline and appeal rules is different.
But the charges were framed under these conduct regulations.
Yes.
There is a separate disciplinary
Procedure.
देखिए
that is indicating the procedure to be adopted by the authority.
Copy আছে নাকি একটা extra copy আছে
Number 7.
But where is this DA regulation has been referred to anywhere in the proceeding?
In the possibly the chart sheet they have referred to.
That sheet was on that regulation.
Format
Allahabad Bank Employees Conduct Regulation.
Conduct Regulation 1970.
Now there is another regulation 76. Both are 76.
1970.
One is conduct, other is Discipline and appeal. Yes.
Discipline and appeal, 1976. Yes.
ঠিক আছে. Yes, now show page what you are showing from their opposition.
Lad. The jural part, lad. দিও না আমার কবিটা দিও দিই তো আমাদের কাছে এক্সট্রা কপি আমার কবিটা মার্ক করা কবিটা কোনটা এটা মার্ক করা kindly see page 276
প্রথমটায় না পড়ে 276.
lad I have made specific amendments in respect to each document, lad. Lad, most of them remain lad uncontroverted. Paragraph 84, lad, kindly see.
Page 276.
84 paragraph.
Hmm.
Made in paragraph 1 and 2 are true to my knowledge. Those made in paragraph 5A to 5mm, 3070 are based on materials derived from records, which I verily believe to be true. Now the rest paragraphs, 5mm onwards, have not been affirmed. Up to 30. 31 to 69, not affirmed. Therefore, the most of the paragraphs of the writ petition remain uncontroverted.
39 to 69.
31 to 69.
Yes.
Ramlat judgment. Judgment.
What was the finding returned on disproportionate?
Yes, I did. It is not disproportionate. Court score observed is not disproportionate. Into not yes. Page 441. Page 441.
Citing trivial reasons.
So far, my first point is concerned, lad.
Yes.
Lad, I tried to find out your Rosh's own judgment. Initially, I was relying on the Supreme Court judgment that has been recorded in the single bench order. Lad. On similar facts, lad, but I find a judgment of your Rosh's, lad. This report of 2017 SCC online Cal 11050.
SCC online can
11050. Relying on the same judgment, I have relied on before the single judge. Let me pass this order, blood. At paragraph blood 15, 16, 17, 18, 19.
যেটা আছে সেটা is different সেটা criminal judgment different পার্টটা আমরা দেখো ডিফারেন্স ব্যাপার
Were you under suspension?
No.
So, Mr. Ahmed, even if we exercise discretion in your favor, there is no guarantee that tomorrow he will join, take the salary, and after 1 month he will start the same thing. Why should we rule out this dark? There, because that would be an order imposing a recalcitrant person and incorrigible persons again upon the employer. This, you know, there is a long line of judgments on this. Banking service having acted in this fashion, you cannot lament that take me back. And if your argument to the effect that yes, he was protesting against the evil that was done, we could have understood.
That I have pleaded in the writ petition, but which has not been denied.
You see, Supreme Court is very clear.
But
that
being an office,
don't place a cantankerous
I
employee
understand.
upon the employee.
But I cannot only all that I can say, that to answer your lordship's query, that your lordships can put him under undertaking, saying that
Then he will come and embarrass the court also. He will come. It is not surprising from his long chain of events.
no, this is the only incident. This is the only incident that he has done, and from the record I can demonstrate that from the beginning he was challenging the order of transfer. Whatever delay, whatever absence is there, the authority is I should have joined in the post and challenge. That he has not done. Only that I understand that this. All those judgments are in the line that there is a charge of theft of bank property, bank assets. In all those,
That is there. But
yes, that is not in my case.
You are asking us to compromise on the conduct of the person.
I understand that. All that I can say, they have tried to frame a chart sheet, but they could not find anything beyond my absence. Any other corruption, nothing. That they could not.
Valid charge.
Yes, my lord.
It's a valid charge. His absence without leave.
Yes, absolutely. Always a valid charge.
Yes, you're trying to make out as if that's a
Always a valid charge. Always a valid charge.
Yes, sir.
Should I refer as a judgment, This is Acha, 1998 Kolkata High Court judgment relying on
copy নেই হলে ভালো হবে
1998 Calcutta judgment. Malacca part. Court has to substantiate the charge.
First, give us the citation.
Yes, this is 1998 2 CHN page 34.
1998 2 CHN
page 34. Para 28.
Yes.
Yes, I am citing that to support my submission that I have shown to lordships that court has relied on regulation 13, which was not there in the chart sheet.
23 also.
23 also. Now,
24.
24 was there in the chart sheet. 24 was there in the last line of the chart sheet. That is a vague. Not para 29. I'm not reading para 28. If this be the position even in a criminal investigation, in that event, we are of the view that the same principle should equally apply to a departmental proceedings. The petitioner has been charged that the petitioner has violated the provision of Rule 3.1 of All India Service Conduct Rules, which provides every member.
29.
I got it.
Hmm.
Merit. If this be the position even in a criminal investigation in that event, we are of the view that the same principle should equally apply to the departmental proceeding. The petitioner has been charged that the petitioner has violated the provision of Rule 3.1 of All India Service Conduct Rules 1968, which provides every member of service shall at all times maintain absolute integrity and devotion to the duty and shall do nothing which is unbecoming of a member of service. Supreme Court in so-and-so case relied on, and Supreme Court observed that Rule 4 bears the heading general, Rule 5 bears the heading misconduct. Draftsman of 1975 rules made a clear distinction about what would constitute misconduct. A general expectation of a certain decent behavior in respect of employees keeping in view corporation culture may be a moral or ethical expectation. Failure to keep to such high standard of moral, ethical, or decorous behavior befitting an officer of the company by itself cannot constitute misconduct. This was hitting Russia's conscience. Unless specific conduct falls in any of the enumerated misconduct in Rule 5, any attempt to telescope Rule 4 into Rule 5 must be looked upon with apprehension, because Rule 4 is vague, like Rule 24 here, and of a general nature. What is unbecoming of a public servant may vary with individuals and expose the employees to vagaries of subjective evaluation. What is in a given context would constitute conduct unbecoming of a public servant to be treated as misconduct would expose a gray area not amenable to objective evaluation. Where misconduct, when proved, entails penal consequences, it is obligatory on the part of the employer to specify and, if necessary, define it with precision and accuracy so that ex post facto interpretation of some incident may not camouflage as misconduct. I believe that this would answer your lordship's query. In similar line of decision has been given by in Supreme Court. This is Supreme Court 1984, 4 SCC, 3 SCC, 84, 3 SCC, AL Kalra.
That is referred to Kalra issue.
And in my case, inquiry report was not given. I do not cite any judgment, to your lordships at least. That
so was that a appellate authority ordering,
yes,
rejecting, giving.
Yes. This is not the appellate at page 192. Kindly see the
first show us that chart sheet. Who are the witnesses?
Oh, that can be ascertained from that. Only documents I have is that penalty.
After the imputation of charge, they must have annexed the list of witnesses.
List of witnesses is with the chart sheet.
No. Now, how
It
many
is
were
not there? Not there in the chart sheet.
Not there in the chart.
Not there in the chart sheet. This is the only documents I have. Page 90. That is the decision of the discipline authority.
No, but in the chart sheet, after the imputation, there is no list.
No.
Provisional document, page 86. Yes, provisional list of witnesses, page 87. Monoranjan Sarkar,
yes.
His whole witness.
Only one.
Has your inquiry officer, sir, has your inquiry officer examined this person? Monoranjan Sarkar?
Yes.
There is a recording of such examination.
Lordship, it would be evident from the, even from the charge sheet as well as the decision of the appellate authority.
No, no, he tendered physical evidence. He
He
was
was physically,
questioned
yes.
by the inquiry officer. He
Yes.
was questioned.
Yes, your Lordship.
Then which are the dates on which the inquiry proceeding was conducted? Do you have that record?
Lordship, I will check up. I will check up. I will certainly bring it. I will certainly check up, your Lordship. But
Then
the
you
fact,
please bring those records.
Lordship, but the
That-
fact remains.
So we will listen to you.
Obviously.
We are putting some questions to you.
Lordship.
One is that whether the inquiry officer conducted an inquiry upon examination of your management witness, yes or no. If it is no, it is gone. That the document was tendered by him in turn. But if he was examined because his depositions were on record or not, please ascertain that. And how the documents were proved or exhibited by whom. These two documents. Every witness, page 87. Yes, anything else?
Can you take some like the appellate authority's decision, my lord?
That is page 80.
192.
No, sorry.
At page 193, at first, second, third, fourth. Fourth paragraph, the appellate authority records service, but how it was not mentioned. Then, my lord,
Fourth para means
first
third charge.
193, page 193,
193.
first, second, third, fourth.
After analysis.
As the charge officer
As the charge.
remained unauthorized absence. Said DA along with inquiry officer's report sent to the recorded residential address by registered post once again for his comment. It was returned undelivered. Thereafter, notices were published in the local newspaper advising Sri Das to collect
No,
inquiry report.
where is that direction that give the...
Yes, madam. Thereafter, madam, last paragraph, court records some of the grounds I have taken up
Yes.
to clause 10. And then observed in the last paragraph, it is observed that the facts narrated in the appellate authority already considered by the disciplinary authority at the time of passing order. No mitigating factors have been brought out in the instant appeal other than those already considered by the disciplinary authority at the time of passing this order. On careful perusal of the appellate, I observed as under. Then opportunity was given, then court's order.
No, where is that? You are saying that inquiry
Yes, yes.
report was given to you after this appellate authority order.
That is at page millet. Na, inquiry report dite bollo.
Oh, that is page 194, first paragraph.
Oh, yes.
It was not received. It was handed over on 21st February 28.
Yes.
An order was passed in May 22. Inquiry report is annexed here.
Inquiry report, yes. 199. And kindly see page 199, last paragraph. First line. Presenting officer submitted the management documents. The documents admittedly were not produced by the witness. Page 199, last paragraph, first line. Have you got it? Presenting officer access management along with documents and witness. All has been done by the presenting officer. The presenting officer submitted exhibits which were numbered in one go ballot. ME to ME13.
He presented Monoranjan as a management.
Presenting officer is presenting the documents.
No, next line.
Yes. He presented Sri Monoranjan Sarkar.
Mr. Singh, you please ascertain this, page 200, the second line. What does he mean by saying that he presented Monoranjan? Did he physically appear before the inquiry officer and tendered his deposition?
What's the paragraph?
Page 200.
200,
Page
first
200.
line. First line.
Second line.
He presented.
Which were numbered as such and such. He presented.
So we are wanting to know, in a disciplinary proceeding, presenting officer is your representative, employer's representative.
Yes, yes.
He will present the case to the inquiry officer.
Yes.
And I will have a defense assistant. I will appear either. Here it was expertise. Now, this Monoranjan Sarkar, did he appear before the inquiry officer and give
Tendered the
deposition? If that is done, then you please bring that record. All right. So, yes,
Deposition he might have given, but whether he has tendered the document. That's the judgment.
That proceeding, we have not got it. That inquiry, how the inquiry officer conducted that proceeding. All right. Yes. Any other judgment you want to read?
In similar line, I do not want to cite the inquiry officer's report needs to be served. For that, I need not have to cite a judgment. Oh, only one thing, one judgment I want to cite. Judgment in the trial, in the single judgment, they have relied on judgment distinguishing the judgment of 2012. That is willful and disproportionate.
That is 10-9.
Yes, but that judgment was relying on a rules which is different from our rules.
Contains the word willful.
Which contains the word willful. Our rules doesn't contain the word willful.
Charge was made under this.
So there is this can be distinguished on facts.
No. In these regulations, there is only another, only willful
Absence.
is not there means what you are saying.
Page 45 and
I'll take some page compilation, page 45. Yes. Follow content.
Yes, Rule 6.1. Regulation 6.1.
Page 45.
Yes. Regulation 6.
What you are saying?
Fix 1 was referred to
Page
paragraph 11.
Running page 45.
Running page 45. No, my compilation.
Yes.
Compilation copy is na.
Yes.
The allegation charge was yes. Charge was in that case was violation of rule 6.1. Regulation 6.1.
Okay.
And when this regulation.
This one there is willful.
Yes.
But in your regulation, that willful term is not there.
No. This is a difference. A second judge's copy. Is willful, what is missing?
Then it goes against you.
No, because in my case,
there was no willful in the charge regulation.
Therefore, there was no charge in 3.1. They have said violation of 3.1. If 3.1 does not have any word willful, then there is no violation of willful. The observation of your lordship judgment on Supreme Court judgment is mere absent is will not do. It must be willful. So they have charged with 3.1. 3.1 does not contain willful.
Then the virus of 3.1 is under check.
No, I'm not challenging virus.
The argument which you're advancing is that the willful is not there in the regulation. In your regulation, willful is not there. So you are framing a charge on the basis of a regulation which does not contain that the absence should be willful.
No, it has fallen from lordships that in terms of 3-1, in my case,
Diligence. That is diligence.
diligence.
Yes.
It's not willful absent. But the charges was
Coordination of Mr. Ahmed Learned appearing for the appellant has concluded his arguments. So, due to paucity of time, Mr. Singh Learned Advocate appearing for the bank, respondent bank, could not complete his
ঠিক আছে।
detective.
Obliged.